considered one of the most misunderstood courses, yet you find that it is the foundation on which our justice system is built. Today, we are honored to have Honor Sedinam Kwadam with us. She brings a deep and practical understanding of the Ghana legal system, sitting as a judge of the circuit court in Accra, and she will be guiding us through some of the core topics. On that note, Your Honor, I'll yield the floor to you.
Oh, right. Hi, good morning. Good morning from Accra.
Morning.
For those of you joining from outside of Accra, good morning from Accra. It's extremely sunny in Accra today. So I am honored to join you for this conversation on the Ghana legal system. And my understanding is that a lot of you are students who are going to be writing the examination for entry into the law school. And of course, some of you are already in the law school because the link was shared generally, even by myself on my LinkedIn profile. So I'm on LinkedIn and I have shared the profile. So I know that apart from those attempting to enter the Ghana School of Law, there are also law students from the law schools. I hear you are not law faculties anymore. Law schools, but undertaking the LLB program, and then those who are already in the law school as well. I'm sure that there are lawyers who are also joining us. So it's just the entire legal community, and I love the legal community because continuous legal education is important for us to, sharpen our brains and make it easier for us to maneuver in the courts, in our offices, in the classroom, lecture halls, generally. So thank you very much for having me and for inviting me to do this all-important topic. Now, the reason it's important for us to understand Ghana legal system is not just about the examination. Don't get it wrong. It's not just about the examination. It's more about understanding where you're working. The legal system is your farm, literally. It is your farm. That's where you're going to plant all your crops. That's where you're going to reap your harvest. So if you do not have a good appreciation, a working understanding of the Ghana legal system, because of course it is in Ghana you're practicing your law or you're hoping to practice your law. If you do not have a working understanding and a full holistic appreciation of the system in which you're going to work, then it means that you're not ready. And that's why this conversation is most important. So let's get right into it. We could go back to a little history to understand how it all started. Pre-colonial systems of adjudication were basically community-based, tribal-based. So you have the chiefs, the family heads, the clan heads adjudicating, because we were in Africa, we were generally clans and tribes. So we would have adjudication being spearheaded by the leaders of the community, i.e., the chiefs, the clan heads, and the family heads. Ebusuapenyin, Pometa, I don't know other languages, but these are the people who would adjudicate matters, even in criminal cases. So, for example, formerly, before the colonialists arrived, if a person stole, a community would decide how stealing would be handled. So they formed the legal system. The community heads, the chiefs, the family heads, the clan heads formed the adjudication system pre-colonial. And then during the colonial era, there was a mixture. It was more or less a mixture of the customary adjudication system and the European system. The Dutch, the Germans, the British, all brought their types of adjudication. So the community where they were found and they had colonized, they were able to successfully colonize. They were the administrative heads of those communities, especially the coastal areas, right? So they would impose their type of adjudication from Europe and combine it with what the traditional leaders, the community leaders were doing, and then have a mixture, sort of a cocktail of adjudication principles and systems to help the members of the community, the citizens, to come up with, I don't know what this is, but Nanaya will take care of it. There's a comment in the comment section, Nanaya, please take care of it. I don't know if it's one of those things. All right, so there would be it's gone, it's been deleted. Yeah, it's been deleted. There would be a mixture of adjudication processes, European and customary, in order to, administer justice at that level. And that's what pertained during the colonial era. But post-colonial, which is after independence, the constitutional regimes that we had continued to incorporate European adjudication systems together with our customary adjudication systems. So we would find in the early constitutions and even in the 1992 constitutions that the sources of law clearly give prominence to the application of common law, rules of equity, then our customary law, then of course the statutory provisions which are founded on the Constitution. So now we have a beautiful cocktail of the systems that we would use in Ghana as our guideline, our lighthouse for the legal field. So we have the statutory provisions, which the head of that, the apex of that would be the Constitution. Currently, we have a 1992 Constitution, then other statutes that derive their validity and authenticity from the Constitution. And then we come down to rules of common law, rules of equity, customary rules, which are laws that are practiced or accepted by communities in the country and which are not repugnant to rules of natural justice and are not inconsistent with any provision in the Constitution. So you see the beautiful cocktail we have. And that, ladies and gentlemen, that is what forms the legal system as we have it now. And it is post-colonial. It is still persisting. Currently, we are in interesting times where there has been established a constitutional review committee. So we probably are in the, the dawn of a new era going to come up. We don't know what it will entail, but we'll see. We'll cross that bridge when we get there. However, what we have now is what we're working with. We're working with the 1992 Constitution, and it provides a beautiful cocktail of legal framework for us. But it comprises of what? The Constitution and other statutes that derive their validity from the Constitution. They must be in conformity with it. And then it contains rules of common law, rules of equity, and then customary law. All these form our legal regime or legal framework that we operate within. But to come and understand how all these apply practically, we'll need to understand the structure, the superstructure of the legal system. And that is the purpose of this conversation. So that was by way of a general introduction to where we came from, where we're at now, and probably where we're probably headed. So that's by the way. Now that we understand that the system operates with this backbone of the law, the legal framework, we need to understand the system. What is the system? What's the Ghana legal system? First of all, you need to understand that it only pertains to Ghana. And that's why it's called the Ghana legal system. So you see that those who study law in the UK and other Commonwealth countries, when they come to Ghana and they want to be admitted to the Ghanaian bar, they still have to take Ghana legal system and pass it, because you're not operating from wherever you did your law, your first law. You're not operating from the UK, you're not operating from South Africa or Kenya. No, you're operating in Ghana. You're going to be operating your law. You're going to practice your law in Ghana, and thus the Ghana legal system. So for those of you who are going to write exams, this is the understanding you have to have, that it is because the legal practice that you're hoping to learn at the law school, or those who are already in the law school, the legal practice you're learning, you're going to practice it in the Ghanaian context. That is why you must understand the Ghana legal system. I have broken the entire topic down for you. The Ghana legal system is a system that governs the legal framework and practice in Ghana. Simple and short, nothing to be complicated about, nothing to be confused about. So the system is structured in a manner that we've got the laws, which I have run through already, and then we've got the physical structure, infrastructure, and personnel who sort of coordinates to allow the practice. And that structure and the personnel involved is what you must become conversant with. The scope and ambit of the operation, what they're allowed to do, what they are not allowed to do, which includes their jurisdiction, their powers, how they operate generally. And that understanding is what gives you 100% knowledge in how the legal system operates in Ghana. So without much ado, we'll go straight to the system, the structure, before we come to the personnel. So I'm going to divide this into two. We'll do the structure, which is the court system, adjudication system, the structures, and then we'll do the personnel who operate within that system. So by the end of this conversation, you would have had a holistic understanding of how the system looks like, what it looks like, how it operates, and then the personnel who have, who work in there and are able to coordinate the system to work effectively, right? So what is this system? Now, this system is made up of adjudicating bodies. Adjudicating bodies meaning entities that have been given power under the 1992 Constitution and other enactments deriving the authority from it, to adjudicate on disputes, legal disputes. If there's a dispute, where do you go to? That's the question. If you've got a dispute with someone, where do you go to? What do you do? I hope that you're taking some notes down. If something pricks your mind, just note it down, bulletin point. But of course, the recording will be sent around so that you can replay at your leisure and, assimilate some more. Also, if you've got questions, I believe you should put them in the comment section. And as we progress, I may be answering some of them as we go, or afterwards, we'll go through the questions. Thank you very much. So this system has got adjudicating entities. And in Ghana, we've got a hierarchy of the courts. So we've got the courts at the apex being the Supreme Court. The Supreme Court of Ghana. I mean, there's nobody in Ghana who doesn't know our Supreme Court. There are even some lay people who think that the entire court system is the Supreme Court and the High Court. The Supreme Court and the High, they don't know about the other courts, but we're going to break it down today for academic purposes, so that we do not think like the lay people out there. The Supreme Court is the apex court of the land. It serves also as the constitutional court of Ghana. In other jurisdictions, they've got the Supreme Court having different arms, sort of divisions. Just like in Ghana, we have the High Court having different divisions. In other jurisdictions like South Africa, they've got the Supreme Court having different divisions. Yes. Would we say that customary law is subject to the Constitution? Absolutely. If you look at Article 11, someone is asking if we would say that customary law is subject to the Constitution. It is, absolutely. Look at Article 11 and see. The laws of Ghana are listed in Article 11 of the 92 Constitution. And one of the criteria to qualify as a source of law is your conformity with the Constitution. So if what is customary law? It is the law pertaining to a group of people. They are custom. So we've got maybe Anglo customs. We've got Vedome customs. We've got Asante customs. We've got Bono customs. So if your custom in your traditional area is in conformity with the constitutional provisions, all of them, like let's say some crimes, you've got a right called widowhood rights. Okay, let's assume that we've got a right like widowhood rights in Anglo traditional. I'm Anglo, so I'll use Anglo traditional area. And it's repugnant to natural justice. It's how they go about it is abusive, physically abusive, mentally abusive, and also because we've proscribed it in our Criminal Offences Act, then we say that because it is our customs, we can do it. And the law says that our customs are a source of law. No, because we've enacted an act which has criminalized it. And not only that, it's offensive to natural justice. It doesn't matter whether it's your custom or not. You have to measure it by the Constitution, by all enactments that have been made deriving the authority and validity from the Constitution. So you can't just get up and say, we've got this custom in our area, and so it is law. The custom that you claim is law must be in conformity with the Constitution or any other enactment which is in conformity with the Constitution. Any law existing which is derived from, yes, the use of customary law. You understand? So if the customary law you are using is not supported by our ground law, then you cannot use it. You cannot use it. There's always a measurement to it. All right, we'll come back to that. Let's progress to the courts. The Supreme Court, I told you in other jurisdictions, they have divisions, but in ours, the Supreme Court is just one. It's just one with a listed number of justices. And then they do all the work. They do all the work right down from constitutional interpretation to appellate cases, hearing appeals, and all that. They do everything. I don't know. The conversation around this is that we should have divisions. Seeing how it operates in other jurisdictions like South Africa, I might be inclined to agree that we should have divisions. And frankly speaking, the amount of work that is placed on those there is just quite overwhelming. So if we've got divisions and they are able to work around those divisions, I think that it will be more efficient, but that's just my humble opinion. And let's see how they'll go about it. Then we come down, right from the Supreme Court, we come down to the Court of Appeal. That's the court right beneath the Supreme Court. I'll come to the jurisdictions, okay? Don't think that I'm done with the Supreme Court. I'm just giving you the structural hierarchy. Yeah, we need to understand the structural hierarchy first before we come to how each of them operates. We come down to the Court of Appeal. The Court of Appeal is the court that is just beneath the Supreme Court. It is an appellate court, so appeals come to it. It's got no original jurisdiction. That's just by the way. Court of Appeal has no original jurisdiction. It's got only an appellate jurisdiction. So all their work is appeal, appeal, appeal. As soon as you hear the name Court of Appeal, it should just click to you. Appeal, appeal, appeal. That's all they do. You get it? Then we come to the High Court. The High Court is a bit more spread out, like a million octopuses put together. It's got a lot of work. It's got a lot of divisions, and it does so much, right? So the High Court is usually the go-to court for the average citizen I'm not talking about community-wise, but at the level where we operate, the lawyers, those attempting to become lawyers and those in the law school, a lot of the lawyers go to the high courts. That's where business is. If you come to Accra, the law court complex, it's business. It's like a market center. That's where all the buzz is, the high court. So they do a lot of the work, and we'll come down to the jurisdiction of the high court again. Just beneath that, we are doing the structure reminder. So just beneath the high court, we have the circuit courts. We have there's a court in coordinate jurisdiction with the high court, and that's the regional tribunals. It exists in our constitution. It is a valid court per our constitution. It's just that it's not being used. It's not being used. It's not being used for quite a number of years. So a lot of people forget that it's still in our it's still in our laws. It is a court that is in our constitution, and it has it's at the same level. It's at the same level as the high court. The regional tribunals are the same level as the high court. That's why in school, when you're learning the court systems, they always mention the regional tribunals, because they've not been expunged from the constitution. Those provisions have not been revoked. They exist. So at any point in time, any entity any chief justice can decide to start using the regional tribunals again. We are hearing things in the media that it's going to happen again. Nobody knows how far that will go. But once it's in the constitution and they can start operating them, the judiciary can start operating them. As long as it's in conformity with the constitution, we just have to look at them and operate in accordance with law. We are always guided by the law. All right, so that's for regional tribunals. So beneath the high court and the regional tribunals, we have the circuit courts. The circuit courts, that's where I work anyway. I proudly work there. It's a very interesting court. It's like in the middle between the baby courts, the district courts, and then the high court. So you are kind of in the middle of transitioning into the big boys and big girls playing field. But no doubt about it. No, don't get it twisted. The amount of work done there is sometimes even more than the work being done at the top, because it is more community-based. So we've got circuit courts all over the country. The circuit court and the next court that I'm going to mention, the district court, they form the lower bench. And recently I have written a very controversial tribute to my colleague lower benches. It's on the internet, it's on Ghana Web, it's everywhere. The law platform, Super Law, it's everywhere. Everybody's talking about it. Ghanaians are saying that the lower benches should be okay with using keke and trotro, because that's what Ghanaians do. But they forget that they do not jail armed robbers like we do. They do not. So it's a bit difficult. I'll come to your question later. Yes, I'll come to your question soon. Thank you, Philip. I'll come to your question soon. So the circuit court does a lot of the work. For example, robbery cases. We don't do robbery cases at the district court. We do robbery cases at the circuit court. Majority, like 99% of robbery cases are done at the circuit court. 99% of narcotics cases are done at the circuit court. 99% of gender-based violence cases are done at the circuit court. So you see, and that is in addition to other jurisdictions exercised by the circuit court. So the bulk of the work is there. And yes, thank you very much, Nanaya, for putting out the Workers' Day tribute, which is making rounds and making me look like a terrible person for asking for the least the system can give lower benches, but I'm proudly doing it. Anyway, so the district courts come beneath the circuit courts. So after the circuit court, we have the district courts. That's the courts that you see around everywhere. you go to Teshinungwa, there's a district court. At Lekma, you go to Bachuna, there's a district court. Tema, it's everywhere, in every village, in every community, in the most remote places, you've got district courts. Why? Because we need justice to be accessible at that level, at the community level, where people don't have to travel to the capital to go and access a high court or a district capital, if you are fortunate to have a high court at a district capital. Right in the community, a person should be able to go to the farm very early at 5 a.m., 6 a.m., come back at 9 a.m., and go to court right next door. So that is the justification behind us having district courts. And when you look at the district court structure, there are different types, okay? We've got district courts that operate as juvenile courts. We've got district courts that operate as family tribunals. The juvenile court and the family tribunal are different. Please get the difference here. A juvenile court deals with criminal matters involving juveniles, that is people under 18 years. But a family tribunal deals with matters pertaining to child custody, child welfare or maintenance, paternity or maternity, that is parentage, and other issues when it comes to children of a couple or just children generally. So a district court may operate as a family tribunal and a district court may operate as a juvenile court. But, you know, it is the Chief Justice that designates a district court as having the power to operate as a juvenile court or as a district court, as a family tribunal, as a family tribunal. If the Chief Justice, if you're sitting at the district court and the Chief Justice does not designate your court as a family tribunal or a juvenile court, you can't on your own as a magistrate just call people and then panel, because they operate as a panel. You see, the family tribunal operates as a panel. The juvenile court operates as a panel. The magistrate of that court will preside, of course. The magistrate will be the president of that panel. So it looks, physically, it looks like a court of appeal. If you enter any court of appeal, you see the three wise men and women sitting there, three justices sitting on the bench, right? That's a court of appeal. So when you come to the district courts, the panel operates in a similar manner. You will see the president of the panel being the magistrate who operates there. And then you will see the other members who are lay people. They are lay people. They are not lawyers. The panel members for the family tribunal and the juvenile courts are lay members of our community. Usually they are social workers, retired teachers, nurses, and other people who work with social welfare, the social welfare office. They are appointed, they are sworn in by the Chief Justice, and they are assigned to certain district courts to sit as either a family tribunal panel or a juvenile court panel. And that's how the district court is. Also, we have certain district courts operating as motor courts. If you've ever been to La, a lot of people have been caught flouting traffic rules, you know, on traffic offenses. They've been sent to the La District Court. The La District Court has a very thriving motor court there. It operates as a thriving motor court. So in Accra, all the time, if the MTTD officials catch you on the road doing something naughty, which is in contravention of our traffic laws, they take you to La District Court. It's because La District Court operates, aside from its general jurisdiction, it operates as a motor court. And we've got many of them like that, but generally, all the district courts operate as motor courts for traffic offenses. Some circuit courts also handle. I mean, it's a discretion of the Attorney General if they think that for this particular offense, they want to take it to the circuit court, even though it's a traffic offense, they want to take it to the circuit court. Maybe it's a traffic offense that was fatal. You know, somebody died. The victim of the traffic offense is a deceased person. So they wanted to go, the Attorney General decides that that case should be prosecuted in a circuit court. Maybe because it may be because the jurisdiction of the district court when it comes to punishment is limited. It's up to to what extent does the Supreme Court reflect the political ideology of the executive? We'll answer that. Yeah, we'll answer that. The district court's punishment jurisdiction is up to 2 years, and the fine is up to 500 penalty units. So maybe the Attorney General thinks that because the victim of the accident died, is deceased, they may want the circuit court to handle it because they may be looking for a higher punishment. It's not because the district court cannot handle that traffic offense. It may, but usually the Attorney General decides that they want the circuit court to deal with it when it's a fatal matter. Another peculiar jurisdiction of the district court is, so you see the district court, the amount of work the district court is doing here. The bulk of the work is being done at the lower court, the lower bench, the circuit and the district court. This is the truth of the matter, okay? Another jurisdiction that the district court exercises is what? Sanitation. We've got, you know, the district assemblies and the MMDCs, they've got this a department called sanitation, environmental and sanitation department, what we used to call tankers, town council. Yeah, tankers. They've got that department still. The EPA is also at the district level, it's decentralized. Now, when they have people who have flouted their laws, they bring them to the district court because the district court is community-based and these MMDCs are community-based. So these offenses are brought to the district court. So a lot of our district court sits as sanitation, environmental and sanitation courts. And that's the fact. So you see the dynamics of the district courts, and that's it. But outside of this core judicial structure, we've got the chieftaincy, the traditional sector. They deal with the chieftaincy matters. We've got the traditional council, we've got the regional house of chiefs, then it comes up to what? The National House of Chiefs. So we've got the traditional councils, then you climb up to the Regional House of Chiefs, and then you climb up to the National House of Chiefs. So when it comes to chieftaincy matters, the traditional councils have to deal with it. If they're not able to deal with it, the Regional House of Chiefs will deal with it. If the Regional House of Chiefs is not able to deal with it, then it goes to the National House of Chiefs. But after the National House of Chiefs has heard it, and is unable to determine the matter or has determined it and a party is aggrieved, the next place to go to is not the High Court, it's not the Court of Appeal, it is the Supreme Court. And that we will come to see is one of the exclusive jurisdictions of the Supreme Court. We'll come to see that. So basically, within these few minutes, I have gone through the superstructure for you to see. There's no way you can't tell me that you cannot appreciate how the structure is now. There should be a drawing in your head by now. You should have it drawn, the hierarchy. Supreme Court at the top, Court of Appeal following beneath, High Court beneath the Court of Appeal, and just beside the High Court, you can put the regional tribunals. Then beneath those two, you put the circuit courts, and beneath those, the circuit court, you put the district courts. Now, you could go beside it and write traditional council, regional house of chiefs, national house of chiefs, and then you link the national house of chiefs to the Supreme Courts. I hope you've drawn that in your small notepad by now, so you will not forget it. The structure is so clear, and it's stuck in your head. I've explained it quite well for you to get the structure. Let's go back to the jurisdiction of the courts. Yes. So we've got different types of jurisdiction. Now, the reason, let me take you back. The reason you need to understand the jurisdiction is because jurisdiction is created by statute, by law. The court does not give itself jurisdiction. A law is giving jurisdiction. A law gives the jurisdiction to the court. Now, if you don't know the jurisdiction of the court, jurisdiction means that the power the court is clothed with to hear and determine a matter. Basically, That's the meaning of jurisdiction. What is jurisdiction? Jurisdiction is the legal authority a court is clothed with to hear and determine a matter, a dispute. Jurisdiction is the legal authority a court is clothed with to hear and determine a legal dispute. That is basically what jurisdiction is. So if you don't know where the jurisdiction is coming from, the ambit of the jurisdiction, it means that you find yourself in the wrong forum. We call it forum. You find yourself instituting a suit in the wrong forum. If not, you find that you acquiesce to a procedure being undertaken in the wrong forum, being on the other side. Let's say you did not institute the suit. You are the receiving end of the suit. Someone has instituted a suit against you. And then you come to court because you don't understand the jurisdiction of the court, because you don't appreciate whether this particular forum has jurisdiction or not. You just acquiesce, you are partaking in the entire thing. Of course, on appeal, jurisdiction can be raised even on appeal. So, I mean, the appellate court can deal with jurisdiction at that point. But imagine not knowing which court to go to. Imagine not knowing the right forum to approach with your dispute. Or even if someone else approached the forum with a dispute and they draw you in, imagine not knowing that you are in the wrong forum and then going through the whole charade of doing a case. Then at the end of 2 years, the case is adjudicated upon, you go on appeal and the appellate court says the trial court did not have jurisdiction. Imagine the waste of resources, the waste of time. Time and money is resources. Imagine the kind of cost you would have cost your client. So this is why it's important to know which court is the appropriate forum to engage in as a lawyer. And that's why you cannot study the Ghana legal system without understanding jurisdiction. It is important to understand jurisdiction because you need to know which court you ought to approach with what suit in order to reduce wastage, okay, wastage of resources, and in order to give the eventual judgment the requisite legal backing. A court that doesn't have jurisdiction and has heard and determined a case on appeal, that entire decision will be quashed. It will be set aside. The appeal will be granted. The whole decision will be quashed because jurisdiction goes to the root of the matter. Jurisdiction is a fundamental matter. So once you get it wrong, even on appeal, the entire work of the trial court will be thrown into the dustbin. And then you have to start afresh, which is a complete waste of everybody's time and energy. So because we have the superior bench and the lower bench, so the superior bench is comprised of what? The Supreme Court, the Court of Appeal, and the High Courts, and of course the regional tribunals, right? And then the lower bench is comprised of the circuit courts and the district courts. So you can see the division right there. The superior courts, High Court, regional tribunals, Court of Appeal, Supreme Court. The lower bench, we don't call it inferior courts. No, those are colonial names. Even though the superior bench is superior, the opposite of it is not inferior when it comes to the courts. The name is lower bench. Please don't approach any court and say this is an inferior court. Don't do that. It's not the right nomenclature. It's lower bench or lower courts and then superior courts. Superior court consists of the Supreme Court, Court of Appeal. Do regional tribunals exist? They exist in the law, in the Constitution. It's been a long time you heard of them, sure. Nobody uses them anymore, but they exist in the Constitution, all right? Yeah. Superior bench, lower bench, superior bench, lower bench. Okay, so let's go back to the types of jurisdiction. I was telling you about the fact that it's important to know the jurisdiction of the courts. We've got different types of jurisdiction. We've got original jurisdiction, we've got appellate jurisdiction, we've got exclusive jurisdiction, supervisory jurisdiction, concurrent jurisdiction or coordinate jurisdiction, review jurisdiction, inherent jurisdiction, and geographical jurisdiction. So we'll take them one at a time, okay? When you come to original jurisdiction, what does it mean? It means that court can entertain fresh actions, the action need not start from another court. That is the court where you can file an originating process. What is an originating process? An originating process is the first process. The regional tribunals have the jurisdiction to entertain both civil. No, usually the tribunals deal with criminal cases against the state or against public interest. That's what they do. Usually it's criminal cases against the state or against public interest. Yeah. But I'm sure we'll get more insights on those things as time goes on. Okay. Yeah. So original jurisdiction has to do with filing a suit, the originating process from that court. So some courts have original jurisdiction. In fact, the Supreme Court has original jurisdiction. The High Court has original jurisdiction. The Circuit Court has original jurisdiction, and the District Court has original jurisdiction. So if you've listened to what I just said, you realize that there's just one court that doesn't have original jurisdiction, which is what? The Court of Appeal. So you can start a fresh action in the District Court. You can start a fresh action in the Circuit Court. You can start a fresh action in the High Court, and you can start a fresh action in the Supreme Court. But you cannot start a fresh action in the Court of Appeal. And it's basically because the Court of Appeal does not have original jurisdiction. You cannot take a fresh action. You cannot start an originating process in the Court of Appeal. But all these other courts I've named, you can file an originating process. And when we say originating process, it is basically the process that you use to start a suit. That's why it's English language, originating, origin, originating, origin. So the process you use to originate a suit, the process you need to file. And when we say process in courts, in legal language, it means the paper, the legal paper. The legal paper is the process we call process. So every time I say process, it's not procedure. Okay, don't confuse the two words. Anytime a lawyer or a judge is speaking and they say the process was filed, it means the paper, the legal paper, the document that was filed, motions, affidavits, etc. Does original jurisdiction mean it has the power to entertain fresh? Exactly, that's what it means. Original jurisdiction means the court has the power to entertain the fresh action by an originating process. So the originating process in many courts, in our legal system, our originating processes are a writ of summons. If you go to the Judicial Service website, Nanaya, if you can put the Judicial Service website link in the comments, that would be great. Thank you. If you go to the Judicial Service website, you will see certain forms. Some of them are originating processes like motions and writs. A writ of summons is an originating process because that is what commences the action. Action is the suit, okay? So that is what commences the action. The writ of summons. It is a form. It is on the Judicial Service website. You can download it or you can type one in your law firm and you can file it. But we have it on the Judicial Service website. So you can just download and print it and fill it out, okay? Another originating process is a motion. What you hear lawyers saying, motion, motion, motion. Thank you very much, Daniel. What you hear lawyers saying, motion, motion, motion. A motion is an application. Please don't let these words confuse you. Lawyers, we are very verbose and legalistic. We like that. It makes us feel like we are in fact, we are in a special field. Our profession is the only profession. Don't tell the doctors I said that. So the motion is an application. An application is a paper. You see, you are applying to the court for something. You are going to ask the court to do something for you. And so you are going to move the court. That's why we call it a motion. You will be making a prayer to the lords. That's why we call them lords, the judges. They are gods on earth. So you'll be making a prayer. You'll be making a prayer to the Lord on earth, seated on their throne, on the bench. And so you have to move them with your prayer. It's like for Christians and Muslims, and even traditionalists, when you are making a prayer to your God, how you implore your God. And that's why it's called a motion paper. That process, that originating process is called a motion paper. It's an application, but you are going to be moving the court to grant you your request. And that's why it's called a motion paper. So a motion paper is an originating process. And then we've got petitions. So the third originating process I'm giving you now is what? A petition. With motions, you can have it on notice or ex parte. On notice means that you notify the opposing party. So that motion, you alone with the judge cannot go and sit in the courtroom and do it. But if the motion is allowed by law to be ex parte, to be an ex parte motion, it means you, the originator, and the judge can go to court and deal with the matter without the other side. And it is allowed by law under certain circumstances in the law. Okay, it's not just you just get up and decide whether you bring the other person in or not. No, because of rules of natural justice, odi alteram partem, hear the other side. If a motion has to be taken ex parte, it must be expressly stated in the law. Okay, so that's for motion. Then we have another originating process I mentioned, petition. A petition. We've all heard of election petition, right? Parliamentary election petition, presidential election petition. So far, we've done 2 presidential election petitions, 2012, 2013, and 2020, 2021. We've had 2 election petitions in our lifetime, and we're blessed. We've got a lot of jurisprudence there. And then another type of petition, apart from election petitions, is divorce petitions. You see, so petitions are a form of originating process. Motions are a form of originating process. And then writ of summons, a form of originating process. So these courts that I say have original jurisdiction. These are the originating processes that would generate the case. They would originate the case. And that's why we say that they have original jurisdiction. You can start off a case in those courts. In the district court, you can start off a civil case. You can start off a criminal case. You can start off a family case. You can start off a divorce in the district courts. Are there not only 3 originating processes, namely petitions, writ of summon? It's not sermon. Sermon is preaching. Summons is summon. So it's different. Sermon is your pastor preaching, and summons is summoning, calling the person to the court. Not writ of sermon, writ of summons, summons. Okay, and then the motions. Yes, these are the originating processes that we have. You're right. Unless I'm forgetting one of them, but these are the ones that readily come to mind. And so you start off a civil suit at the district court, criminal suit at the district court, family suit at the district court, divorce at the district court. You can start off all these at the circuit court as well. You can start off all these at the high court. You can start an election petition, parliamentary election petition at the high court, and you can start all these at the Supreme Court, including constitutional interpretation suits at the Supreme Court, and also presidential election petitions at the Supreme Court. So these courts, apart from the Court of Appeal, all these courts have original jurisdiction. You can start off a human rights action at the High Court. Human rights action under Chapter 5 of the 1992 Constitution. You start at the High Court, no other courts. It's an exclusive jurisdiction. When we come to exclusive jurisdiction, you understand it. Okay, it's at the High Court, it's not at the Supreme Court. The Supreme Court's exclusive jurisdictions are different, and we'll come to that, okay? So this is for original jurisdiction. Now we move on to appellate jurisdiction. When we say a court has appellate jurisdiction, I told you that jurisdiction is the legal authority a court is clothed with. Patrick, unless you cannot type your question, I am not taking questions by raising of hands now. Thank you very much. So you can type it down in the comment section. Thank you very much for your understanding and cooperation. All right. So appellate jurisdiction is a court having the legal authority to hear an appeal. An appeal is that a decision has been rendered somewhere. You're not happy with it. You're not excited by it. You think that for some reason the trial court erred, and we say erred. The trial court erred. Maybe the weight of the evidence does not support the finding or the judgment. The judgment is not supported by the weight of the evidence, probative value and all that. Or maybe there were some errors in law, some other reason. For whatever reason, you're not satisfied with the judgment of the court of first instance, that is the trial court. You are entitled to file an appeal. So any court in our system, I have described the system to you, any court in our system that can hear an appeal has what we call appellate jurisdiction. This is all it means. That's all it means. It means that the court can hear appeals, simple and short, nothing complicated. And which are these courts? Obviously, the district court cannot hear any appeal. Where would you hear the appeal from? Which court is beneath the district court? It cannot hear any appeal. So please, ladies and gentlemen, the district court does not have any appellate jurisdiction. Please, I learned the human rights issues involve more than one person. The jurisdiction is the Supreme Court. Yes, if it has to do with public policy, if it has to do, basically not just more than one person, it's not about the person. If the human rights case has to do with persons, it's supposed to be the High Court. But if it has to do with public policy, it has to do with public interest, then the appropriate forum is the Supreme Court. We'll come to that, okay? I'll answer your question soon. All right. So appellate jurisdiction, the district court does not have any. Circuit court, neither. The circuit court has no appellate jurisdiction. The High Court has appellate jurisdiction. And why do we say so? When you have civil appeals and criminal appeals from the district courts, it is the High Court you take it to, which means that the High Court has jurisdiction to hear appeals from cases that were heard and determined by which court? The district courts. Civil and criminal appeals from district courts go where? The High Courts. Why is that we can't start, the Court of Appeal doesn't have original jurisdiction? It's because the Constitution says so. The Constitution says the Court of Appeal should not have original jurisdiction. It is strictly an appeals court. That's why. There's no other reason. It's because we are bound by the Constitution, and the Constitution says the Court of Appeal does not have original jurisdiction. Simple and short. All right. So civil and criminal appeals move from the district court to the High Court. Please note it down in your notepad. Civil and criminal appeals move from the district court to the High Court, not to the Circuit Court. If you've drawn the structure on your notepad by now, you should be doing some arrows here and there. That's how I used to study as a student. I liked pictorial images, you know, like I like images. It sticks in my head more. By now, you should be drawing arrows. Appeal arrow, civil and criminal appeal arrow from district court straight to the High Court. You see that it has jumped to the Circuit Court, but that is the rule. Then civil appeals from the Circuit Court. So now we move to the Circuit Court. Civil appeals from the Circuit Court go where? They don't go to the High Court. Guess what? It jumps the High Court and goes to the Court of Appeal. Let me take that again. Civil appeals. When there's a civil case in the Circuit Court, like the court I sit in, if I determine a civil case, like let's say a land case, a land matter, or a divorce matter, or liquidated claim matter, money matter, cash, and I give a judgment in my Circuit Court, if one of the parties is aggrieved and they want to file an appeal, they will not go to the High Court. The law says that the High Court has no jurisdiction to entertain appeals, civil appeals from the Circuit Court. Where does the appeal go to? The Court of Appeal. The Court of Appeal is the court that has jurisdiction to hear appeals from civil cases that were handled by the Circuit Court. So we've done civil cases appeal from the Circuit Court. It goes to the Court of Appeal. Now, criminal cases from the Circuit Court, that's where I sit. The Circuit Court, criminal cases from the Circuit Court go to the High Court. Ladies and gentlemen, get the difference. Criminal cases from the Circuit Court go to the High Court. Civil appeals, please, is it because both said? Yes, that is true. I was just coming to that. You're preempting my thoughts. So, criminal cases appeal from the Circuit Court where I sit will go to the High Court. But civil cases from where I said the circuit court, appeals go to the Court of Appeal. And the reasoning that has been given by our superior court benches, our lecturers, and all those who hold, it's because they say it's because both the High Court and the Circuit Court use CI 47, the civil procedure rules, that we both use the CI 47 as amended. The Circuit Court and the High Court both use the CI 47. So an appeal will lie to the Court of Appeal and not the High Court. It is not that I am in agreement. I am a person who always questions the status quo. Even if the law is written in black and white for me, I am going to think outside the box and ask why. Why should it be like that? Can we think of an alternative that makes more sense or is more acceptable? So if you're saying that the reason civil appeal should move from the Circuit Court to the Court of Appeal is that both the High Court and the Circuit Court use CI 47, why is that the criminal appeal should go to the High Court? Doesn't the High Court use the same Criminal Procedure Act, Act 30, with the Circuit Court? That's my question. If your justification is that because the High Court and the Circuit Court used CI 47 as amended, appeals from circuit should go to Court of Appeal, is it not true also that the High Court and the Circuit Court use the same Act 30 in criminal cases? So wherein lies the justification? But that's the position of the law currently, unless we move past it and do something different. So let's learn it for academic purposes and for practice, that this is the position of the law. Civil appeals from Circuit Court goes to the Court of Appeal. Criminal appeals from, yes, they both use Act 30. Criminal appeals from the Circuit Court go to the High Court. So you see that the High Court is entertaining appeals, criminal appeals from both districts and circuits. I hope you are drawing the map now. Is there a case that affects in relation to civil? No, I haven't seen a case to that, the position I'm saying yet. I haven't seen it. It's just a position of the law. It's in the Court Act, and so we are all just going by it. Right, unless we change the Court Act when it comes to civil appeals and then the CI 19, the Court of Appeal rules of procedure. If we change those ones, then if we change the stated law, then of course this our reasoning would find some place. But as of now, there's no law that supports you and I our reasoning. So let's leave it at that. Let's just apply the law as it is. So you see that the High Court is entertaining criminal appeals from both the circuit and the district courts. The Court of Appeal will entertain the civil appeals from the circuit courts and also entertain criminal and civil appeals from the High Courts. Excuse me. Had a water break. Use the CCC formula, civil case. Yes, please use the formula. Formula always work. Formulae always work. For students, you must have formula for learning, at least for the passing of your exams, right? So now we come to criminal and civil cases at the High Court. Where do the appeals go? It's straightforward. The only appellate court, the court that has only appellate jurisdiction, Court of Appeal. So now we've seen that Court of Appeal entertains civil appeals from the circuit courts and then criminal and civil appeals from the High Court. Then, of course, we've got the Supreme Court. The Supreme Court entertains appeals from one, National House of Chiefs. Supreme Court entertains appeals. Sorry, before I continue with the Supreme Court, the Court of Appeal also entertains appeals from parliamentary election petitions from the High Court. I will soon tell you that the High Court has exclusive jurisdiction when it comes to parliamentary election petitions. But the only appellate court that can entertain the appeals from that decision will go to the Court of Appeal. So at what instance or in what cases will the Circuit Court entertain appeals? The Circuit Court has no appellate jurisdiction. Ladies and gentlemen, I cannot emphasize this enough. Both the district court and the circuit court have no appellate jurisdiction. Whose cases are they going to appeal on? They are both lower courts. They have no appellate jurisdiction. It is only the Court of Appeal, the High Court, and the Supreme Court which have appellate jurisdictions. And that's what we are learning. The High Court has appellate jurisdiction from cases, criminal and civil from district courts, criminal from circuit courts. The Court of Appeal has appellate jurisdiction, civil and criminal from high courts, and then civil from circuit court. Why do we refer the superior court as court of records? Now, we refer to them as court of records because they are the courts that have been stated as the judiciary in the Constitution. And they keep records. That is why. But it's just one of those things that I myself find a problem with, because even you see the jurisdiction of the lower courts were summary in nature. So the magistrate will just put you in the box, take some evidence and adjudicate, apply the law and adjudicate. So they were not really setting out full records like that. But the superior courts, they are constitutionally created. Lower courts are created by an act of parliament. That is the Courts Act, Act 459 as amended. Currently, Act 459 as amended. The lower courts are created by an act. But the superior courts are created by their jurisdiction is created by the Constitution. And that's why they are courts of record. Very well. So the appeals from parliamentary election petitions go to the Court of Appeal and it ends there. You cannot move from the Court of Appeal to the Supreme Court. You're welcome. You cannot move from the Court of Appeal to the Supreme Court when it comes to parliamentary election petitions, appeals coming from the High Court. No. When you do the election petition, parliamentary election petition at the High Court, and you are aggrieved, you go to the Court of Appeal, and that ends it. You cannot move from the Court of Appeal to the Supreme Court, okay? Then for presidential election petitions, it is at the Supreme Court. We'll get to that. The appellate jurisdiction of the Supreme Court has to do with the National House of Chiefs appeals. Appeals from the National House of Chiefs come to the Supreme Court. Appeals from Court of Appeal, civil matters, criminal matters come to the Supreme Court. So that is basically the appellate jurisdiction of the Supreme Court. We've now understood, and I say so authoritatively because I have done it very well, according to me, that we understand what's the difference between Act 29 and Act 30. That's a very good question, Selo. Act 29 is the Criminal Offences Act, Criminal and Other Offences Act. It creates the offences and prescribes the punishments sometimes. But Act 30 is the procedure. Act 29 shows you what are crimes in Ghana, which acts are considered as crimes. And sometimes it shows you how the punishment should go by. But Act 30 is the procedure. Do you agree with some legal luminaries who argue that superior courts are referred to? Oh, I'll have to open that, but we'll come to that again. It's a lot. If it's short, I'll answer because I see it pop up on my screen. But if the question is long, I'll have to answer later on, okay? Yeah, so can parliamentary elections be instituted or unhappy at... No. Parliamentary election petitions begin at the High Court and end at the Court of Appeal if an aggrieved party appeals. Appellate for circuits. Can you take it again? Yes, sure. The circuit court has no appellate jurisdiction over any other court, but civil appeals from the circuits go to Court of Appeal. Criminal appeals from the circuits go to High Courts. Civil appeals from the circuits go to Court of Appeal. Criminal appeals from the circuit go to High Court. If you forget, just remember that the judge who gave this lecture is a circuit court judge. Judge Sedinam is a circuit court judge. So if you go to her court and you did a civil case, if you are aggrieved, you have to go to Court of Appeal. Who are some of the Court of Appeal judges you know? Justice Akabuafo, Justice Dennis, Justice Cheba for... Yes. So if you have... if you are aggrieved by Judge Sedinam's decision at the circuit court in a civil matter, you take it to Court of Appeal, a panel of 3 members, maybe Justice Cheba will be sitting on it, Justice Archer, Justice, all of them, all the Court of Appeal judges, yeah. Then if you are aggrieved in a criminal matter, you take it to the High Court from Judge Sedinam's court. How can the Supreme Court balance the principle of stare decisis? Oh, your question is long, so we'll answer it later. I can't see all of it. What? Yeah. Wow, the questions are just flowing. So we'll deal with them later. I'll continue. We finish with appellate jurisdiction. We come to exclusive jurisdiction, which is a very important topic. Exclusive jurisdiction has I mean, the word exclusive alone should prompt you that it is jealous and it does not allow anybody else to exercise that jurisdiction. It is jealous. That jurisdiction is jealous. It's exclusive to that court. Okay? It is exclusive to that court. That jurisdiction is exclusive to that court. Why do we say that a jurisdiction is exclusive to a court? It means that no other court can entertain it. So if I say something, it's reserved for a particular court and no other court. If I say something is exclusive to me, it means that nobody else can do it. So when we say a jurisdiction is exclusive to a court, it means no other court has the legal authority to do that thing, to entertain that matter. So let's look at some of the courts that have exclusive jurisdiction. I'll start off with the main one. Thank you very much, Thomas. I'll start off with the main one. The main one has to do with the Supreme Court. The Supreme Court has certain exclusive jurisdictions there. If you are another court and you attempt it, the way they'll blast you in their decision for attempting to usurp their authority. Every court that has exclusive jurisdiction has those sentiments. They guard it very jealously. So the Supreme Court has exclusive jurisdiction. I mentioned some in our conversation. Yeah, it's funny. Yeah. One of them is presidential election petitions. We have seen two of them, and we have seen clearly that the two of them were started and ended at the Supreme Court. It was commenced and concluded at the Supreme Court. And this is because the Supreme Court has exclusive jurisdiction. So if you go for presidential elections and you are aggrieved, you cannot go and put that petition before any other court in this land. In fact, you cannot put it even in another jurisdiction, let's say outside of Ghana. No. It is the Ghanaian Supreme Court that has exclusive jurisdiction over presidential election petitions. That's one of its exclusive jurisdictions. Another type, note it down. The Supreme Court has exclusive jurisdiction in interpreting, thank you, Kelvin, interpreting the 1992 Constitution. Anything that has to do with interpretation of the Constitution, it is who? The Supreme Court that has exclusive jurisdiction. So let me give you a scenario. Judge Sedinam is sitting at the circuit court, and in a civil case, the parties have raised an issue, a question of interpreting a constitutional provision, maybe right to privacy. Is Judge Sedinam clothed with the requisite jurisdiction to determine that question? No way. Even if the question is raised in a suit that is before Judge Sedinam sitting at circuit court, no way. Judge Sedinam doesn't have any power to make that determination of that question. What Judge Sedinam has to do is a procedure under Article 135, I believe, of the Constitution, where Judge Sedinam has to do a referral. It's called a referral. So whether it is a district court, circuit court, high court, or not, even the Court of Appeal, if a question comes up as to the interpretation of a constitutional provision or as to determining whether an act is done in excess of a constitutional provision or non-conformity of a constitutional provision, constitutionality, compliance with the 1992 Constitution, apart from the human rights one that the High Court has, only the Supreme Court can interpret the Constitution and determine whether an act is made in excess of the Constitution or, contrary to the Constitution. Only the Supreme Court. So what's the trial courts? Yes, of course, that's another exclusive jurisdiction to hear appeals from National House of Chiefs. Only the trial court, what the trial court has to do is something called referral. The trial court has to pause, refer that question of interpretation to the Supreme Court, wait for the determination, and then read that determination, apply the determination coming from the Supreme Court to the case before it. That's how it's done. You pause, you refer that question to the Supreme Court as a trial judge. The Supreme Court will sit and determine it and send you back the determination, and then you will apply the determination to the suit before you, and that's how it is done. Now, another exclusive jurisdiction is what someone has typed for us. Exclusive jurisdiction to hear appeals from the National House of Chiefs. That's another exclusive jurisdiction. So you see that these jurisdictions I've stated are exclusive to the Supreme Court. Another exclusive a court that has exclusive jurisdiction, as I have stated, is the High Court for human rights matters under Chapter 5, enforcement of fundamental human rights, right? But as I already stated, if it has to do with public interest, you have to go to the Supreme Court. But if it's just a personal interest, personal fundamental interest, then you can go to the High Court. And only the High Court has exclusive jurisdiction. Yes, you are right. Determination of whether the production of a document in proceedings has that's an exclusive jurisdiction of the Supreme Court. So if a trial court is hearing a matter and there's a question as to whether an official document, say bordering on what they call it, national security issues, should be disclosed, that court doesn't have the jurisdiction to determine that matter. The matter must be referred to the Supreme Court for determination as to whether or not the official document has to be disclosed. That is an exclusive jurisdiction. So generally, exclusive jurisdictions are guarded jealously, as I said. Yeah. Let's move on to supervisory jurisdiction. Certain courts have supervisory jurisdiction, and these are the High Courts and the Supreme Courts. They have supervisory jurisdiction because they are able to supervise courts beneath them. The Supreme Court has supervisory jurisdiction over all courts in the land. The High Court has supervisory jurisdiction over the lower courts, that is the circuit and the district courts. I'll take that again. The Supreme Court has supervisory jurisdiction over all courts. The High Court has supervisory jurisdiction over the lower courts, that is the circuit and the district courts. And in their exercising their supervisory jurisdiction, they may, is the High Court having exclusive jurisdiction, both fundamental? No, it is not interpretation, it is enforcement. The High Court has original jurisdiction when it comes to enforcement of fundamental human rights. It is not interpretation of a constitutional provision. If it has to do with interpretation, it has to go to the constitutional court, which is the Supreme Court. But if it has to do with enforcement, it has to do with, the High Court. Can High Court have supervisory jurisdiction over court? No, never. Oh, did you not draw the structure in your notepad? If the High Court is beneath the Court of Appeal, there's no way the High Court will have supervisory jurisdiction. What is supervision? When we say you are supervising someone, definitely you are above the person. By necessary implication, you are above the person. For me to exercise supervisory power over you, I must be above you. Your supervisor at work, your supervisor in school. So how can the High Court exercise supervisory jurisdiction over the Court of Appeal? It's an abomination. It's a crime. Loose sense of the word crime. Okay? High Court has supervisory jurisdiction only over, the lower courts. I'll come to the Court of Appeal ought to have supervisory jurisdiction. I see. Over the High Court. The Court of Appeal should have supervisory jurisdiction over the High Court. I'll come to your questions, okay? So supervisory jurisdiction, in exercising that, the courts, both the Supreme Court and the High Court, can make certain orders. They have the prerogative rates like quo warranto, certiorari, habeas corpus, prohibition, mandamus, all these prerogative rates, they help in reviewing in order to supervise the courts beneath them. So the Supreme Court and the High Court, upon application by an aggrieved party, can issue a prerogative writ as certiorari to quash the decision of a court that they supervise. They can issue a prerogative writ such as habeas corpus for them to produce a person, a body. They can issue an order of mandamus, asking an official person to do one thing or the other. They can issue a prerogative writ in the nature of a prohibition to prohibit someone from doing something, an official from doing something. They can issue, or a court from doing something, quo warranto, asking the entity what gives them the mandate to do what they are doing. You get it. So these are prerogative writs. It is a supervisory jurisdiction they don't have. The Court of Appeal doesn't have that jurisdiction. I told you that the jurisdiction, when it comes to jurisdiction, it's not, jurisdiction doesn't fall from the sky. Jurisdiction is statute created. So if the statute doesn't have it, you don't have it. The only jurisdiction that a superior court have, which is not written in statute, is inherent jurisdiction to do justice. That's all. And that's very vague. It's broad, but then it's not specific like the ones you're talking about, supervisory, appellate. Once it is those other types of jurisdiction, not inherent jurisdiction, it must be stated in a statute, either the Constitution or an act deriving its validity from the Constitution. That is why we say jurisdiction is statute created. The only jurisdiction that's not statute created is the inherent jurisdiction of the Superior Court to do justice. But all other jurisdictions, you must find it in a statute, either an act of parliament, some other legislative instrument deriving its legal authority or validity from the Constitution or the Constitution itself. Right at the beginning of this conversation on jurisdiction, I made it a point to make it clear to you, crystal clear, that jurisdiction is a creature of statute. So if the law does not say this court has this jurisdiction, it doesn't. And when the law says this court has that jurisdiction, it does. It's that simple. We are lawyers in the making. We are bound by the law. Okay? All right. Then we have courts that have coordinate or concurrent jurisdiction. So that's for supervisory jurisdiction. We've got courts that have concurrent jurisdiction. It means that those courts, they exercise certain jurisdictions at the same time. They can do it. They can all do it. For example, criminal cases, circuit court, district court, high courts, you can start criminal cases in either of them. Usually the Attorney General decides which of the three courts it would start the prosecution from, depending on the punishment they are looking for. No, Joel, you cannot start an election petition, parliamentary election petition from the Court of Appeal. I told you that's the appellate courts. From the High Court, you go to the Court of Appeal for parliamentary election petition. All right. So I was talking about concurrent or coordinate jurisdiction. But the High Court, the District Court, the Circuit Court, they all try criminal cases. They all have the same... my internet is paused. Okay, I'm back. The High Court, the Circuit Court, and the District Courts have coordinate jurisdiction, original jurisdiction in starting criminal matters, for example, dissolution of marriages in civil cases, divorce, what we call divorce. You can start a divorce at the District Court or at the Circuit Court or at the High Court. You choose which one suits you, okay? Just like that's the same way the Attorney General decides which court is appropriate, especially in light of Act 30, Act 29. If when we come to criminal jurisdictions, you will see that it's the nature of the offense may determine which court you should go to, okay? So we'll come to that. So that's for concurrent. Some courts have concurrent coordinate jurisdiction. We have review jurisdiction. So you know that the Supreme Court can review its own decision, right? Yeah. The Supreme Court is not bound by its previous decision. So the Supreme Court can review its own decision. So when a panel of the Supreme Court makes a decision, another panel can be set up to review it if an aggrieved party applies for review. The District Courts, Circuit Courts, and High Courts used to have review powers. For the District Courts, I think it's Order 32. And under the Circuit and High Court, it was Order 42 of CI 47. But they've been revoked. Those provisions have been revoked by CI 134 and CI 133, I think. New CIs have revoked the review powers of the District Court. So at first, the district court could review its own decision. Like if a magistrate makes a decision, the district court itself can sit on an application to review its own decision, but no more. There's a new CI that has done that. Yeah. The Supreme Court, listen, the Supreme Court can depart from its decision, and that is why it is not bound by it. The fact that you can depart means that you are not bound by it. If we say you are bound by it, it means that by hook or crook, you cannot depart. You are bound by it. If you say, for example, a circuit court is bound by the decision of all the superior courts, it means you cannot derogate from, you are bound to follow it. So that what the Supreme Court does is that it can follow its previous decisions, but it is not bound to follow. It can depart from it. And the Supreme Court has shown that severally. You understand? Then we have the review jurisdiction I was telling you about. No lower court can review its decision anymore. No lower court, even the High Court under CI 47. Yeah, it cannot review its decision. Yes, there's a new CI that has taken that power away under Order 42. There used to be a review power under Order 42 of CI 47. No, Circuit Court and High Court cannot review their own decisions anymore because the CI has taken that power away. It has revoked Order 42 of CI 47. So there's no way any aggrieved party could put an application for review before the Circuit and the High Court. Same for the District Court. Another CI has revoked that review power. So clearly, it is only the Supreme Court that can review the decisions of the other courts, right? I told you about inherent jurisdiction already. It is to do justice by making appropriate orders and enforcing such orders. It is basically to do justice. It is an entire. Is it possible to form an entirely new panel for review at the Supreme Court? If they have the numbers, why not? But you see, if they don't have the numbers, they cannot. If they don't have the numbers, they cannot form an entirely new panel. Let's say, there's no law binding the empaneling officer, the Chief Justice, from restricting him or herself to a certain people. So it's an exercise of discretion. If the Chief Justice empanels these group of people, they can be the panel for the court of first instance, and in the appeal. Of course, the better approach would be to put in new people so that there's new ideas. But if some of them repeat too, there's no law saying they can't. There's no law saying they can't. But it's a matter of numbers. If the number is good enough that would be the better approach. So most of the time we've seen it like that, better approach like that. Yeah. Maybe we should. I'll be enlightening us on that matter pretty soon in a write-up on the need to form totally new panel for reviews, completely new panels. That would be the best approach. Then we have geographical jurisdiction. Okay, when it comes to geographical jurisdiction, district courts especially have that issue. There's a district court in Adabraka, Workers' College, right? There's a district court there. So it caters for cases coming from all over Accra Central. Dansoman has a circuit court, but Adabraka district court caters for all that. Now, there are two district courts at Medina and Adenta. Kaneshi District Court, yeah, that's the one they now call Adabraka. They stopped calling it Kaneshi, please. That court is no longer Kaneshi District Court. It's called Adabraka District Court because that location is Adabraka. Then you have a case at Adenta, and the magistrate from Adenta is there. The court is there. Then you come and pick a judge, a magistrate from Adabraka to go and sit inside the Adenta courtroom, Adenta District Courtroom, to, adjudicate the case. That is wrong. When it comes to district courts, the jurisdiction you've been given geographically is the post that the Chief Justice has posted you to. the duty post. So if you are posted to Adabraka, you can only deal with cases that fall within the geographical jurisdiction of Adabraka. You cannot go and sit in another court. Maybe you travel to your village in Tamale and then you see a district court there because you're a magistrate, then you go and sit there. So no magistrate has the power to go sitting in different courts. Same way, when you look at our rules of procedure, you can see that geographically, there's a venue for every type of case. Look at CI 59 as amended, look at CI 47 as amended, you will see venue. You see venue. There's an order called venue. In CI 47 as amended, it's order 3. Venue. It shows you where geographically you ought to institute your suit. Okay. And those are for civil cases. For criminal cases as well, we have jurisdiction determined by Act 30, geographical jurisdiction. But a lot of the times you see that attorney generals decide where to prosecute cases because sometimes they say the security of the court staff or police officers or even the accused person, when a crime is committed in a community, maybe the community is so incensed that they want to come and kill the suspect or the accused person. What happens when one judge is on leave? Okay, we'll talk about that. When judges are on leave, we have another judge assigned by the Chief Justice to relieve that judge. So that one is an administrative matter. Once you have a letter saying, go and sit in this court and relieve, then you can do that. So without a warrant telling you that you can go and sit in another judge's court, you don't have the power to go and sit in another judge's court. For example, when I was transferred from Adenta to Accra, I still had judgments to go and deliver in Adenta. It doesn't mean that because I used to sit at Adenta, I'll just get up on my own and go and sit there and render my judgments. No way. I don't have that power. In fact, that's an act of incompetence, a mark of incompetence and misconduct. You have to apply to the Chief Justice to give you something called a warrant to go and sit in another court. So when judges are on leave, the Chief Justice gives warrant, or supervising High Court judge gives warrant for another judge to relieve. It's called relieving. Okay. But if you are on transfer and you have to go and finish up your cases, then you will apply as a judge. You apply to the Chief Justice or your supervising High Court judge to give you a warrant to go and sit in your previous court to finish up certain cases. All those things are administrative exercises done by the Chief Justice and supervising High Court justices. Right. So, geographically, Act 30 also determines. I was telling you that sometimes. No, I'm no longer at Adenta. I'm at Accra Circuit Court 7. I don't sit at Adenta anymore. I'm at Accra Circuit Court 7. So the Attorney General sometimes, for the safety of all persons, all stakeholders, may decide to prosecute elsewhere. It's within their purview to do that, regardless of the geographical issues. If they can justify it to the courts, they can always prosecute elsewhere, because in all things we are looking at public safety, public interest, right? So it will not be deemed as forum shopping when it has to do with crimes that have taken on a public character, public interest character. The courts and the Attorney General would want to do things to protect the suspects, the accused persons, for their safety, the court officials, the police personnel and police stations. So if someone, for example, someone kills someone in Bibiani and the whole community is so upset, they want to kill the person, an eye for an eye, they want instant justice, and the police manage to save the person and keep the person on remand pending prosecution, the best approach would be the Attorney General taking the case somewhere far away so that the people would calm down. And then it would take a lot for them to travel and come to Accra to come and cause mayhem, right? But if you prosecute the person there in Bibiani, even if there's a high court in Bibiani to try the person, because that would be a jury trial, right? Murder would be a jury trial. Still, the safety of the people cannot be guaranteed. So for many reasons, the Attorney General, regardless of geographical jurisdictional rules, may decide to apply to the court for the people to be sent to another court and prosecute the case elsewhere. Am I a lecturer at any of our universities? No, I'm not. I've not been up. I'm only a judge, but I guest lecture in some universities. Some of the deans and lecturers invite me for certain topics that are pertinent to my practice because I'm an industry person. Judges are allowed to do that. You know why? Why are you asking? Why have you seen me appointed anywhere by any university? Why do you ask? Anyway. So that's for geographical jurisdiction. And you have a lecturer flair. Oh, wow. Yes, I keep hearing that. Maybe we should consider it in the future. We'll think about it, okay? Thank you very much. I appreciate the compliments. So when it comes to jurisdiction generally, I told you it must be statute created. But if you look at I go often to UPSA. So if you come to there's this LI. I don't know if you've seen it. LI 2429. The Attorney General brought that LI to increase the monetary jurisdiction of the courts, the lower courts. If you go online and you search for LI 2429, you will see it. Download it because it's not it's not, I'll address all those things. Stop distracting me. It's not every case in a civil matter that you can send to any court. Okay, so we've learned about all these types of jurisdictions. It's important for us to place it within context now. So when we go to Court Act, under the provisions in Act 459 as amended, certain monetary jurisdictions have been placed. So let's take the lower court. Let's start from the lower court. The district court, if you look at the Court Act as amended by LI 2429, I hope you've downloaded it. For liquidated claims arising out of contracts or torts, the sum claimed should be beneath what? 500,000 Ghana cedis. It's also a type of jurisdiction. That's why I'm mentioning it now. If we've gone through all those types of jurisdictions and I don't mention this, then we've missed something. I don't want us to miss anything. So when it comes to a district court, if you are going to file a liquidated claim arising out of contract or tort or any other money issue, your claim should be below 500,000 Ghana cedis. Also, if it is a land matter at the district court, the value of the land has to be below 500,000 Ghana cedis. Also, if it is an estate matter, for example, you are applying for letters of administration, LA, or probate, the value of the estate has to be below 500,000 cedis. So you see, when it comes to the district court, for land, liquidated claim, and administration matters, estate matters, all these matters have the 500,000 jurisdictional limits. But when we come to the circuit court, the 2 million Ghana cedis ceiling applies only to claims arising out of contract and tort, liquidated claims, the money claims, okay? And also estate matters. That is LA, probates, applying for them, the estate value. The difference here is that unlike the district court where the value of land in land litigation has to be beneath 500,000, Daniel, you are right. When it comes to the circuit court, there is no limitation. There is no limitation when it comes to the circuit court. The value of the land doesn't matter. And I've written a paper to that effect. Nanaya, if you can find my paper on, put the link there, the jurisdiction of the circuit court in land matters. It's a jurisdiction at large. So you can say that both the circuit court and the high court have the same jurisdiction when it comes to land matters. It doesn't matter the value of land. It can be $10 million. It can be a land at Cantonment or a land at East Legon. Thank you very much, Nanaya, for posting that article. I had to write an article on this matter because I found that many legal practitioners kept bringing applications to the circuit court saying that the monetary limitation of the circuit court is 2 million Ghana cedis, so I should decline jurisdiction. And most of my colleagues at the circuit court were facing the same applications. And I thought, no, let me put this on paper and then have it published so that all of us in the legal fraternity will have this matter laid to rest once and for all. So it was the last nail in the coffin. We've buried this issue. Both the circuit court and the high court have the same jurisdiction when it comes to land litigation, occupation, ownership, and possession of land. It is limitless. The value of the land does not matter. So please don't make this mistake in your exams anywhere. That's the jurisdiction of the circuit court when it comes to land matters is limited to the 2 million Ghana cedis ceiling. It's only estate matters and liquidated claims that the 2 million cedis affect the circuit court's jurisdiction when it comes to the monetary limit, okay? But the district court, it affects all of them. Land, probate, administration, and then liquidated claims. I hope this point is very clear. Then, when you see this monetary limits, there's a proviso. So ordinarily, for the district court, once the money is about 500,000 Ghana cedis, the court lacks jurisdiction in all those circumstances I've mentioned. And for the circuit courts, the court lacks jurisdiction for those two circumstances I mentioned. But the law has made it possible for the parties. Look at section 42(3) and 47(3) of Act 620. That's the Courts Act. Act 459 as amended, per Act 620. You will see, if you buy the Courts Act, it's put together. All the amendments are put together in one document. So you see it there. The parties in the suit can agree in writing, and the court must take this note down. Both the district court and the circuit court must write it down that although this suit, ordinarily, this court lacks jurisdiction because of so and so and so, the 500,000 or the 2 million monetary ceiling, the parties have written by process filed and agreed to clothe this court with jurisdiction. So we've said that jurisdiction is statute created. So you see that even where the parties can write and clothe the court with jurisdiction, regardless of the lack of jurisdiction with respect to the monetary limits, the Courts Act has provided in that statute a means for the parties to do it. And that is also statute created. It's not outside of the statute. Crucially, the parties may agree because the statute provides for it. Very apt. It's not outside the statute. So it's not a jurisdiction conferred by the parties, so to say. Strictly speaking, it is not. It is also embedded in the statute. So even that jurisdiction the parties gave the court is statute created. Ladies and gentlemen, that is solid understanding of the phrase jurisdiction is statute created. Okay? Very well. Now, there's a question that people usually ask. If at the end of judgment, why the civil proceedings on charges orders CI 87 has not been amended? Well, once we have the LI 2429, you are supposed to apply it, mutatis mutandis, okay? There's a question people ask, why, if there's a judgment, let's say in a district court, after computing all the judgment debts, we get 600,000 cedis. If you add the interest, we get 600,000. Does that not mean that the jurisdiction has been exceeded? No. Jurisdiction is gleaned from the claim, not the judgment. I hope you understand. Of course, let me take a water break. Thank you. Of course, in the court, given judgment, thank you, given judgment, it has to give the judgment within the ambit of the claim and within the law. So if a court knows its jurisdiction, for example, I know that my monetary limit is 2 million Ghana cedis, and I'm giving compensatory damage. Why would I go beyond that? Because the claim is asking for compensation. So I must also act within the law. But the situation I'm describing is one where the claim is, let's say, let's use the district court. The claim is 200,000 Ghana cedis. But by the time we compute all the interest in 5 years, we've reached 600,000 Ghana cedis. Does it mean that the court doesn't have jurisdiction to enforce that judgment? No. Interest is not part because the claim was 200,000. It's just unfortunate that the interest computation brought it above 500,000, but that is not considered when it comes to the monetary jurisdiction. Okay, so when you are writing your essays or you are answering your questions or you become a lawyer, once your claim is within the monetary limits jurisdiction, you are good to go. If at the end of computing the interest, it goes beyond, that doesn't matter. It's not considered as a breach of jurisdictional rules. Okay, I just thought that I should tell you that. Okay. All right. Now, if I'm right, I have touched on almost everything when it comes to the courts. Okay. I've touched on almost everything when it comes to the court structure. Maybe in answering the questions, we'll touch on the other things. So let me quickly run through the personnel of the court. Then we come to the question because the questions will help us address any portions of the Ghana legal system that I may not have addressed. Okay. So the personnel in the court, let's start from the Supreme Court. We've got the Chief Justice being the president of the court. And at different points in time, each panel may be presided over by somebody else. It's one other justice of the Supreme Court, but the Chief Justice is the president of the Supreme Court, okay? And then we have justices of the Supreme Court. If you go online, you see all their names over there. Then we have justices of the Court of Appeal. We have quite a number of justices of the Court of Appeal, considerable number of them. Then we have High Court justices. So all these three groups are called justices. So when you're addressing a Supreme Court judge, a Court of Appeal judge, and a High Court judge, you say justice. And if you're addressing a Circuit Court judge, you say judge. If you're addressing a District Court judge, you say magistrate. So District Courts, the judges who sit at the District Courts are called magistrates. Now, the judges who sit at the Circuit Court are called judges. That's why I refer to myself as Judge Sedi, and you can call me Judge Sedi. Okay. So those of us at the Circuit Court, we are judges. Those at the District Courts are magistrates. Those are the High Courts, Court of Appeal, and Supreme Court are justices. That's the nomenclature. Don't get it twisted. Now, how you address them when you go to courts. This is all part of Ghana legal system. When you go to the District Court and you're addressing the magistrate, you say, Your Worship. They are worshipped. Your Worship. When you come to the Circuit Court where I sit and you're addressing me and my colleagues, you say, Your Honor. So we are like the Americans. So if you've been watching Boston Legal and The Firm and all those other dramas, legal dramas, law firm dramas, you hear Your Honor, American, Your Honor, Your Honor, Your Honor. So it's the Circuit Court judges who are called Your Honor in Ghana, just like the Americans. Then in the High Courts, in the Court of Appeal, and in the Supreme Court, they are called Your Lordships and Your Ladyships. Okay, so they are the ones you say, my lady, my lord. A lot of lawyers, because they don't want to get the name wrong, because if you go to a Circuit Court judge and you go and say Your Worship, the Circuit Court judge will feel demoted, you see. So a lot of lawyers, because they don't want to get it twisted, they call everybody my lord, my lord. And even we women, they call us my lord. And it doesn't really matter as long as you've not demoted the person, okay? But the right way of addressing is Your Worship for District Courts. Write it down. You'll forget. Write it down. Your Worship for District Courts. Your Honor for Circuit Courts. Your Ladyship and Your Lordships for High Court, Court of Appeal, and Supreme Courts. Apart from the judges who adjudicate matters in all these courts that I've mentioned, we've got certain court staff who operate in these courts. The first person of importance is the registrar. And you need to know, every court has a registrar. The registrar is appointed to sit as the administrative supervisor there. You see, so we have the judge and we have the registrar. The registrar's work is cut out for them. They take care of the registry. The registry is the soul or spirit of the courts. They run the show. When it comes to paperwork, filing, and money, they take payments, the cashier's office. When it comes to service of processes, we have the bailiff's office. When it comes to clerkship in the courts, we have the clerk's office, we have docket clerks, and we have interpreters, we have recorders. So you see all these people, they work under the registrar. The registrar supervises them. The registrar coordinates them. The registrar instructs them so that there's a smooth running of the courts. We've got cashiers, we've got bailiffs, we've got clerks, we've got clerks who work in the courtroom, and we've got clerks who work in the docket session. And then we've got interpreters and recorders. We've got ushers as well. So these staff, they belong to the judicial service. Then we have a judicial police unit. They give us bodyguards and court warrant officers, the police officers in the courtroom. When you enter any courtroom, and some of you should, all of you should be visiting courtrooms. Go and visit courts and see how physically, how it operates. You've got the clerk sitting in front of the judge, and you've got recorders sitting behind computers typing. We've got an interpreter in the courtroom who interprets the court proceedings to people who use other languages apart from English. The working language of the court is English. But people come and they opt to use other languages. So we always have interpreters. If we do not have an interpreter of a certain language in that particular court, we write for the registrar to procure one from the pool. There's a pool of interpreters. And if we don't have that language's interpreter in the, in the pool, the registrar can write to the Institute of Languages and they'll give us one. So Chinese, Indian, just name the languages. We always get interpreters because we've got people studying languages in Ghana. So we get interpreters. Then the recorders are the ones who type. They type court proceedings. They type orders and all those things. They are behind the computer. Does the registrar have to be a lawyer? No. The registrars, you apply. The judicial service floats adverts for all these positions. So if you want to be an officer of the judicial service, like a registrar, a clerk, a bailiff, an interpreter, or a recorder, you apply for the position on the judicial service page, and then you come for your interviews, etc., and then they employ you. The registrar is an administrator, so usually they have an administration background. They don't need to be lawyers, but currently, everybody's going to school. So we've got a lot of our registrars who have done their LLB. Some have the BL certificate, so they are lawyers. We've got a lot of clerks who are lawyers. And so human resource development, it is their own prerogative. It is not the judicial service that is causing them to go to school and all that. No, it is their personal prerogative and they must be commended for it. A human being who does not improve on their intellect or their capacity is one that's stagnant. You can't be stagnant unless you are not well, you are sick, and you are or financial constraints. But for our staff, they must be commended for improving on themselves by taking themselves through school. And most of the majority of them do it side by side working. So, is this trick for the interpreter to be an actual interpreter? Oh, no. When we don't have the actual interpreter, the court can administer the interpreter's oath to any of the staff, even litigants in the courtroom. We can pick anybody in the courtroom and say, listen, do you use this? Who uses this language? And someone raises their hand. I use this language. As a lawyer, there was once I was sworn in as an interpreter to do Ewe interpretation in the courtroom. I went to court for my own case and they couldn't get an Ewe interpreter. And the judge asked, who speaks Ewe here? Who understands Ewe? And I raised my hand and I was administered the interpreter's oath. So there's an interpreter's oath. And once it was administered, I was able to your questions will be addressed. The law questions will be addressed, okay? And I was able to, do the interpretation. So these are the staff that supports the court. They are the administrative staff. Then the judge, of course, is the judicial person who adjudicates. All these persons work together with the court system to, shore up the court so that our legal system is properly situated in the structure, such that administration of justice is seamless, okay? So you cannot talk about the Ghana legal system without the personnel. These are the personnel that are working. There's an office called Judicial Secretary. I'm sure you've heard it before. That is the office. It's a constitutional office, and the Judicial Secretary is on different councils and boards, okay? So that is the Judicial Secretary of the Judicial Service. There's a Chief Justice, and then there's a Judicial Secretary. There are Deputy Judicial Secretaries as well. And they all do the same administrative work for the Judicial Service under the Chief Justice, okay? And their office is provided for under the Constitution. Then we have directors of departments, HR director, finance director, procurement director. We've got different directors. So it's a whole organogram, and it's administration. So if you go through our website, you see what we have as an organogram, and then you know the personnel who form part of the Ghana legal system. Yes, so that's the personnel. We've done a lot on the law, the structure, the court structure. We've done jurisdiction. By way of summary, that is what I have. So we'll start going through the questions, and we've got a lot of questions. We'll start from the beginning. Quick question, my lady. Would you say that the customary law is subject? So I answered that, or it was completely independent. I answered that it's subject to the Constitution. Okay, it's subject to the Constitution. Exceptions to the use of customary law. Yes, so there are exceptions to the use of customary law. I told you that. If I may ask, customary offenses which are not prescribed in the 92 Constitution or any other cannot be adjudicated by the court. Yeah, of course, if you say that this practice is against your custom, it is not a crime. What is a crime? A crime must be prescribed. It's a conduct that is prescribed by law. So there must be an enactment that says this. So I'm wearing an orange, let's say it's orange and black kimono. If an orange and black kimono is a crime, it must be stated in an enactment in the country. You can't just wake up and say, according to the tradition of Anglo people, wearing orange and black kimonos on Saturday mornings is a crime, so the court should adjudicate. No, it's not a crime. A crime. So, for example, adultery, many customs or religions, even Christian religion especially, are not excited about adultery. And in the civil law, adultery is against the ordinance marriage, right? But is it a crime? It's not a crime. Adultery is not a crime, because there's no law that says it is an offense to commit adultery, and if you commit adultery, the punishment is 2 years imprisonment. No. A crime must be prescribed by law and punishment prescribed by law. So if your customary practice is not prescribed by law, it cannot be a crime for anybody to adjudicate upon. It cannot be an offense. It has to be enacted. Does customary law apply to a specific geographic area, or it is tied to a particular ethnic group, clan, or family? Customs are peculiar to a group of people, whether you call them clan, ethnic group, or family. Customs are peculiar, but it must be custom that is acknowledged as part of a custom. You must come and lead traditional evidence to prove it. You understand? You must lead cogent traditional evidence to show that this thing has been practiced for long, over 100 years, over 200 years. Our custom is to eat, how do you call it, kola nuts on Monday mornings between 6 a.m. and 7 a.m. You see, if it is not proved properly, not just because you are saying it, we'll say it's a custom, okay? If multiple ethnic groups with distinct customs coexist in the same area, so each of them will be able to come and lead traditional evidence to prove that that particular conduct is a custom peculiar to them. For example, an Ewe person living in Achim territory. So the custom will not be just because you are living in Achim. You are an Ewe. So it is not where you are living. Maybe your marriage ceremony was done in accordance with Ewe custom, Anglo custom. So that is the customary law the court will apply, not because your house is in Achim that will apply Achim. No, you married under your Ewe customary law. So when the case comes to court to find out whether a customary marriage exists, we will use the custom under which you got married. Okay. It's not where you stay. It is the custom applicable to you as a person, your personal law, personal custom law. But if that is your personal custom law and you are living in that area too, then both of them coincide nicely. Which customary law takes precedence? Well, personal customary law will take precedence, except you are from that place and then you practice that custom as well. Would the Ewe custom be recognized and practiced even if the conflicts with Achim custom? Yeah, because the conduct you are talking about, it must be your personal law. But if it is, let's say, a practice that is abhorred in the Achim area, they say it is a taboo to go and fetch water from this river. And it is their custom. Whether you are Ewen or not, you are bound by that custom because you live there. But if it is something personal to you, like marriage, then it will be the custom of your people. I hope you get the difference. Yeah, assuming both customs are constitutional. Yeah, I hope you get the difference now. Okay, the article is there. My lady, to what extent does the Supreme Court reflect the political ideology of the executive that appoints its justices? And how does this affect judicial neutrality? This is a paper you want me to write. This is a paper, Agana, Joel. Why don't you write on it and let us all read? You go and write the paper and let us all read. You know, in America, right, when they are going to appoint justices to the Supreme Court, everybody talks about their personal values. What's their policy? Where do they lean towards? So for jurisdictions like America, it's not something to shy away from. It's so open. They are honest about it. I'm right wing. I'm left wing. I like abortion. I don't like abortion, right? But here we behave as if people don't have personal policies or all that. We are still pretending about it. And to that extent, that is why these questions will come up. Maybe at a point in time, if we become open about it, that this judges' policy, they lean towards conservatism, or, you know, they are liberals. You are liberal or you're conservative. Then maybe you can say this, their political leanings could, or ideologies could be easily gleaned. However, as it stands now, we are in hiding. You know, as it stands now, we are in hiding. So the appointer has a political leaning, because as of now, under our constitution, it is the president that appoints. So because everybody knows the political leaning of the appointer, definitely there's a perception that if you are appointed by this president, then you may have the same leanings as the appointer. But it may not necessarily be true unless there's evidence available. For example, if there's evidence that this person had a previous connection with this political leaning, or was actively participating in that political leaning, then the perception would be stronger, right? So it's a matter of being honest about this conversation, that if the appointer is of this political leaning and appoints people in their tenure, people may have the perception that, oh, people appointed under this particular president are for this particular political leaning. But it may not necessarily be true. The proviso is that if there's cogent evidence, hard evidence that that particular justice was actively participating in party politics, then the perception becomes stronger. But as it stands now, I do not have an opinion on that, because I'm also part of the system. If the previous government did not appoint me to a court, another government will come and may appoint me. So if you ask me this question, what are you trying to make me do? If the next government appoints me as a justice, people may generally perceive me as one party or the other. If another government comes and they appoint, so well, we can't help people with their perception. If there's evidence to show that there's actual this, that's different. But if there's no evidence, people are allowed to have whatever perception you know they want to have. They are entitled to it and they should have it. And if you want to write on it, that would be fine. We are developing our jurisprudence. So it's good that you write on these things and share your thoughts with all of us. Maybe the Constitutional Review Committee may come up with a better way of appointment of justices to help with eroding this perception. It may help. Actually, I believe that it may help because it's not fair. It's not fair that even though somebody may not have participated actively in any party politics, just because an appointer has appointed you, everybody says that, oh, you are this color or you are that color. I mean, it's very hard. It's very hard for those who are judges. It's very, very hard. You are sitting, Ghanaian would say, you are sitting you're somewhere. Some president has decided to appoint you, maybe on your merits, you are a good lawyer, you are a good judge, and they think that you should be appointed. Then all of a sudden, the general perception is that, oh, once you're appointed by this person. So maybe we should look at the law on appointments rather, so that we can clear that hurdle once and for all. Nobody will come and talk about this anymore. It affects people negatively. If there's hard evidence, fine. But if there's no evidence, this perception, the least said, the better. Next question. Does regional tribunal exist? I think I answered that. Yes, they exist in the law, in the constitution. So yes, they are legal. Do regional tribunals have the jurisdiction to entertain both civil and criminal? I answered that, criminal and against the public. Please, does original jurisdiction mean it has the power to entertain a fresh matter? Yes, I answered that. It means that are there not only 3 originating processes, namely petition, writ, and origination? Yes, I answered that, yes. I learned when the human rights issues involve more than one person, the jurisdiction is the Supreme Court. It's not really about the person. It's about whether it affects public interest or public policy. So it's not really the numbers. If we all say that our human rights, maybe a number of us, 10 of us say our human rights have been affected, why should we go to the we want to enforce our fundamental human rights. Why should we go to the Supreme Court? So if you take the education right, the Rastafarian case, Achimota School, that's my alma mater, Achimota School, and you take those cases, they were more than one person. So it's not really about it's about the public interest. If you are coming for the enforcement of fundamental human rights when it deals with generally, like right to bail under Martin Table number 2, right to bail, all offenses should be bailable. Yeah, that one you have to go to the Supreme Court, not to the High Court. So it depends on the interest that is at stake, personal or public. What is the difference between mistrial, appeal, res judicata, doctrine of mootness? Wow, what's the name? Paul John, that was loaded. Now, mistrial is where the court rules that there was such error, palpable error in law, that the entire trial should be read as a mistrial. So they'll order that it's a mistrial and we should start afresh, maybe trial de novo. An appeal is where the merit of the case is being appealed against, the judgment. The aggrieved party says that the judgment was against the weight of the evidence, or the weight of the evidence was against the decision, or for some other reason they want an appellate court to overturn the decision. That is an appeal. Res judicata has to do with a case that has been adjudicated already. So there's a fresh case, but the party thinks that the case falls on all 4 with a previous case between the same parties, the same subject matter, and it's been adjudicated upon, and so the case is res judicata. It means that it should not be relitigated. That's the meaning. And the doctrine of mootness, it means that there's a case, let's say there's a case before me, and it has to do with Easter, and the case was brought in January, and it has to do with organizing Easter festivities at Accra, Independence Arc. You know, somebody wants to organize an Easter festivity independence act. And then the case was pending. Ah. And then Easter came and Easter passed. So after Easter in May, today, if we call the case, is it not moot? It's moot because the case has been overtaken by events. The Easter has happened and the case is moot. Honestly, there's no point. It's like a moot court. A moot court doesn't have any merits. So it's just, we're just doing something to represent something. When the case is moot, you have to stop it. It's been overtaken by events. That's the mootness of the situation. All right. Why is it that you can't start original jurisdiction at the appeal? I told you, jurisdiction is statute created. So they've told us that the Court of Appeal has no original jurisdiction. It has only an appellate jurisdiction. We follow the rule. Is it because both the Circuit Court and the High Court equally use CI 47, or is because both of the courts have the same jurisdiction in such matters? They said it's because they use the CI 47. That's the appeal has to go to the Court of Appeal from the Circuit Courts, and that's why. Please, is it because both circuits and high courts apply the same? Yes, that's why. All right. Is the case to the effect that in relation to civil appeals from the circuit court? Yes, it's in relation to the civil appeals from the circuit court. Civil appeals from circuit court go straight to the Court of Appeal. They don't go to the High Court. I will use the CCC formula, civil case to circuit, from circuit court to Court of Appeal. That's fantastic. Please, everybody learn the CCC formula. Civil appeal from circuit court go to Court of Appeal, triple C. Okay. So at what instance or in what cases will the circuit court entertain appeals? None. Circuit court has no appellate jurisdiction. Why do we refer the Supreme Court of Records? I answered that. Yeah. Hey, where am I? Okay, please, what's the difference between Act 29 and Act 30? I think I answered that. 29 is the Criminal and Other Offences Act. Act 30 is the Procedure. When we say Procedure Act, it spells out how to go about the procedure. If you have a criminal case, what do? Arrest warrant, arresting, production before court, trial and indictment, summary trial. What does the court do? All those procedures. That is what it means. So Act 30 is the Criminal Procedure Act 1960, Act 30. And it has amendments, so you should look at the amendments as well. Then Act 29 is the Criminal and Other Offences Act. That is the offense creating enactment, okay? So 29 creates the offenses. Act 30 shows the procedure to go about those offenses. The judgments are recorded and referred. But a lower bench too, we record our judgments. And then the referral, what you mean is binding precedent. Oh, okay. I hear you. Please, do you agree with some legal luminaries who argue superior courts are referred to courts of record because their decisions are binding? Oh, no, that is not why. If your decision is binding, doesn't mean you are a court of record. That your decisions can be cited. Even decisions by lower courts can be cited as a persuasive effect. You see, but when it comes to binding effect, that is not what makes the court a court of record. Okay. To me, that is not the reason. That's not the reason. And I think it's an unnecessary piece of information we keep flying around. Which court is not a court of record? Every court has records. And if it's about the binding effects, we could use another nomenclature for that. We could come up with something better. The things that were done in 1960 and the rest, it doesn't mean they fit our evolved minds today. So we can always come up with better names. Can the parliamentary election be instituted or an unhappy party institute a court of appeal? You start parliamentary election petitions at the High Court and you appeal to the Court of Appeal. The appellate for circuit again. Okay. Appeals, civil appeals from circuit court go to Court of Appeal. Criminal appeals for circuit court go to high court. How can the Supreme Court balance the principle of stare decisis, respect for precedents, with the need to adapt to evolving societal? Are you asking me I'm not a Supreme Court judge. I'm not a Supreme Court justice. So how would I know how they need to? But as an intellectual, I could hazard an opinion, a humble opinion though, that balancing the principle of stare decisis, it means that the precedents are there and we should ordinarily be guided by them because it creates for certainty of law. Certainty of law is one of the most important characteristics of good law, a good legal system, because people must be certain of the position of the law. If it keeps swinging like a pendulum, it means that people wouldn't know what they are expecting from courts, and it makes people take the law into their own hands. It makes people uncertain of the position of the law. It affects even academia. Because if the lecturers are confused about the position of the law, they wouldn't know what to teach the law students. And constitutional law especially will be all over the place because the positions keep switching like a pendulum. So certainty of law requires that we give due reverence to stare decisis, of course, but we cannot be oblivious of the fact that we live in a society that's not static. We are evolving constantly. Even the brain we had in 1960 is not the brain we have today. Today, we see law students writing articles chastising Supreme Court decisions, saying, there was one I read that was so interesting. It said, constitutionality on its head. Wow. So the beautiful ones are not yet born. For that reason, we must be fully aware that we need to evolve. So when the society has evolved and there's a new need, there are new ways of viewing things, perceiving the law, we should not shy away as a Supreme Court from applying the evolved law within the context even of the stare decisis, but changing it to fit our peculiar circumstances. The law was made for the people, not the people for the law. So if the law is not evolving, society will be growing apart from the law, and people will start taking the law into their own hands. It means that the law is not meeting the needs of the society, and law must necessarily meet the needs of the society. This is why we must evolve. So I agree with you that in as much as we respect the principle of stare decisis, because we are an evolving society and the law is made for the people, not the people for the law, the apex court must, and I must admit that the apex court has shown that leadership. When you look at Martin Payable number 1 and number 2, you can see clearly that the apex court saw the need to change the law. The act is there, but if we look at the fact that we now understand that debt is not a crime, debt, D-E-B-T, is not a crime. From our understanding from international covenants and treaties, debt is not a crime. Why should we have a law that says that if someone stands as surety for an accused person and the accused person absconds, we should imprison that person just because the person signs a contract with the Republic of Ghana that they will produce the accused person? So because of that evolution, we now know that the contract between the surety and the Republic of Ghana is a civil contract that must be enforced in a civil manner, and there's no need to imprison people. And that is why I have even written, and Nanaya, if you have that article, please put it in the comment section. I wrote together with one lawyer, Emmanuel Babubwa Esquire. We wrote an article together that Order 73 of CI 47 as amended and Order 12 of CI 59 as amended should be changed, should be revoked, because they allow for the arrest, imprisonment, and other infringements on rights of liberty in a civil case where judgment has not even been procured. It's called an absconding warrant procedure. So I have clearly, together with my co-author, attacked the presence of absconding warrants in our civil procedure. When people have been sued in court, there is no way under our current dispensation in the world, under the international covenants and treaties, And even in our own judgment, ex parte PPE Limited, that we should imprison people, we should arrest people on an ex parte application called absconding warrants. We should arrest them just because a suit has been instituted against them, that we are afraid they will not pay the judgment debt. No, there is no way. And so I've written on that. It will be posted for your digestion. Go and look for it online. It's about Order 73 of CI 47 on Order 12 of CI 59. I've said that we are an evolving society. So, I mean, the laws that we have now, think outside the box. When you read the laws, don't think that because it's written in black and white, we should continue. If your mind can think of something better in light of the evolved society you live in now, the world is a globe. If you have seen other laws abroad, other best practices abroad, why don't you write on it? And if you have a means of speaking to people who make the decisions, policymakers, parliamentarians, the Attorney General's department, put these laws, these write-ups before them, suggest a policy change. If the law is not changing to meet our needs, we are a doomed society. Thank you for that question. It has made me give a lecture on it. What are the differences between courts of appeal and appellate courts? And before I even forget, you know, even with the law school, cramming or chewing your statutes, Act 29, section this, you memorize them, rote memorization before you go and write exams. I've written a paper on that as well, Rethinking Legal Education. Nanaya, please put that one too there. Go and read it. If the SRC president of the law school is around, I hear they are doing elections, the current SRC president should get in touch with me ASAP to use that paper to put a petition before the GLC for that policy to change in 2025, after our Lord Jesus Christ. We are still memorizing section this of Act 29 to go and write exam. What is wrong with us? Why would you be memorizing section this of Order this of CI 47 to go and write exams just for the purposes of writing? In court, do we have lawyers coming to court to rattle section this and order this? No. As I'm speaking here, I'm making references to laws. Some of them, I use them often, so it comes naturally. But if I have to read, I will read. We saw Justice Ifeanyi Saribotwe and Justice Lydia Mafo going on Joy FM and other media platforms, and they were discussing jury trials. Did they go empty-handed? Did they not go with their books and they were flipping the pages on TV, on the internet for us to see? So why do we expect law students to be examined without having the benefit of the statute with them? Are you testing their memorization or you are testing the application of law? Please go and read that article and see my argument. SRC presidents, draft a petition. Get in touch. I am willing to support you in this advocacy to stop the memorization of statutes for purposes of exam. It is wrong. It occupies the space of students, the mental space. So they don't have enough space to learn how to apply laws, understand the principles properly, and apply them to given situations. We must be able to send Act 20 into the courtroom. The school can give it to us. As students, the schools can give it to us. We can foot the bill in our school fees. So when we are going to write civil procedure, the school should share brand new CI 47 as amended, no annotation, no cases inside. Fresh one. When you finish writing the paper, you send your copy away. Act 29, same for criminal procedure, Act 29 and Act 30. Whatever law you are going to write, the raw statute, I'm not saying annotated or textbooks, I'm talking about the raw statute, the one you are having to cram, CI 47, you are cramming or that this, or that you are memorizing. Oh my goodness, what a waste of mental space. And I became a lawyer before I realized that was abuse in law school. And we don't want that to continue anymore. It has to stop. SRC presidents, get in touch with me. Let's fight this fight for law students. Next question. Can please the appellate, sorry, what's the difference between Court of Appeal and appellate court? So appellate courts are courts with appellate jurisdiction. So the High Court is an appellate court for district court cases, civil and criminal. The Supreme Court is an appellate court for appellate cases from National House of Chiefs. But Court of Appeal is only one. It is the Court of Appeal. That's the name of that court, the Court of Appeal. Just like we have the Supreme Court, the High Court, the Circuit Court. The Court of Appeal is the name of that court. But appellate courts are courts with appellate jurisdiction. I hope the difference is clear. Can you institute a presidential election petition at the High Court? No. It's always at the Supreme Court. Okay? Presidential election petition, you've seen two. You cannot go to the High Court or Court of Appeal. You can't go anywhere. Just, it's the exclusive jurisdiction of the Supreme Court, okay? I always enjoy your presentation. You make the topic look very simple and easy for us to understand. Keep it up, my lady. Thank you as well. Yeah, I'm enjoying this lecture. I'm glad you enjoyed it. I'm glad I've enjoyed myself as well. Supreme Court has exclusive jurisdiction interpreting good. Kindly type your question. Okay. Okay. No way. Exclusive to hear appeals in cases or matters affecting chieftaincy. That's an exclusive jurisdiction of the Supreme Court. Determination of whether yes, we've said that. Referral, we've said that. Is the High Court having exclusive jurisdiction to both enforcement and interpretation, or only enforcement, please? It's enforcement. Can High Court have supervisory jurisdiction over? No. Over Court of Appeal? No. High Court has supervisory jurisdiction over lower courts, circuit and a district. Human rights for Supreme Court cases in human. I'm of the candid opinion that the Court of Appeal also ought to have supervisory jurisdiction of the courts below it, because its part to entertain appeal from the High Courts itself is a form of supervision of. Well, we do not equate supervisory powers with appellate powers, and that's why we cannot call the Court of Appeal a supervisory court. Okay, appellate jurisdiction is totally different. It goes to different things as opposed to supervision. Supervision is a totally different thing from appellates. Okay, and that's why the Court of Appeal is not a supervisory court. Is the Court of Appeal appellate jurisdiction in parliamentary election matters an exclusive jurisdiction? Yes, it is. The Court of Appeal's jurisdiction, because that's the only court that can hear the appeal from the High Court when it comes to parliamentary election petitions. Why does the Court of Appeal not issue these prerogative writs? Because it's an appellate court. It's not a supervisory court. All right. Can a parliamentary election petition be issued directly at the Court of Appeal? No. Or must it commence at the High Court? High Court. And only reach Court of Appeal through appeal? Yes. Yes. What happened in that case? Well, you have to tell us what happened in that case. Maybe they said that it can start from the Court of Appeal. No, it cannot start from the Court of Appeal. It has to start from, which year was that? 2004. It has to start from the High Court, please. The Supreme Court is rather bound by its own decision, but can review. It can depart. It can rely on it, but it can depart. It doesn't mean that it's bound by it. It can rely on it, but it can depart. If you are bound, you cannot extricate yourself from it. Being bound, if I bind you now, can you extricate yourself? No. The Supreme Court may vary or reserve or maintain its earlier. Yeah. And they can depart. They can even depart. They can depart from their previous decisions. Is it possible to constitute an entirely new panel in a review case? Yeah, it is possible if you have the numbers. Why not? When can lower courts depart from the decisions of the higher courts? It's called distinguishing. The lower courts can distinguish themselves. You see, when you have a set of facts and you think that those facts do not fall on all fours with the facts in the case being cited as binding on you, you can distinguish. So the art of distinguishing is a legal, technical exercise that if you don't know how to do it, you end up messing the whole case up. So you must learn the art of distinguishing. If you think that the facts of the case before you do not fall on all fours with that which is in the case that pertains to the case that's been cited as binding on you, you can do distinguishing and, say that you are not bound by it. There was a High Court decision with regards to district courts not having jurisdiction to entertain divorce petitions of marriages that are ordinance marriages. And so a lot of the lower bench courts were feeling that they were bound by the decision. But when the case was, before the Court of Appeal spoke on it, when a case was brought before me and the lawyer applied for the district court to declined jurisdiction, I distinguished the case before me, not in the sense of distinguishing per se, but I applied the Court Act, Act 620, which is superior to judicial precedent. You know, in the hierarchy of authority, statute comes before judicial precedent. So the High Court decision was a judicial precedent, and the statute said the district court had jurisdiction to entertain divorce petitions, even on ordinance marriages. So I just applied that. And another reason I gave was that the special law on jurisdiction is the Court Act and not the Matrimonial Causes Act. The general law, the Matrimonial Causes Act, had to do with it was a special law on matrimonial causes, not on jurisdiction. If you want to determine the jurisdiction of a court, it's the Court Act. So using those two grounds, I did not allow the High Court decision to bind me. But subsequently, a Court of Appeal has spoken on this matter, and the matter is settled. District Court, Circuit Court, High Court, they have the same jurisdiction when it comes to divorces, whether the marriage is customary or ordinance or Mohammedan. All right. Supreme Court can sit on its proceedings by 5-panel review. It's however, in reviewing, is 7. Yes, it has to be 7. Constitutional matters, they are 9. 9 justices sit on constitutional matters. What happens when one judge is on leave? I told you, the supervising High Court judge or the Chief Justice would appoint one judge in the area to relieve that judge. On relieving duties, you are not to take evidence and adjudge the case. You hear motions, you determine motions, you give dates, you deal with interlocutory matters, basically, when you are relieving. But it's different from additional duty. If a judge is doing additional duty, it means that judge is the substantive judge of that court in addition to their original court. So at a point in time when I was the magistrate of Teshinungwa District Court, Lekma Court, I was the additional magistrate for La District Court as well. So I was not relieving. I was taking evidence in both courts. I would take evidence and adjudge the cases in both courts. But relieving is different. In relieving, you've been asked to hold the fort for someone who has gone on leave. Okay. My lady, are you a lecturer? So, Thomas, you never told me why you were asking if I was a lecturer in any of our universities. I guest lecture in some of the universities when I'm invited by the vice deans or the deans or some of the lecturers to come and espouse some knowledge as an industry person. So judges, we are industry persons because we are practicing in the courts. And our code of ethics allows us to help with legal education. Yeah, so we do it for free. That university will be blessed. That was your reason. That university will be blessed to have you. Thank you very much for the compliment. You are the best. Thank you very much. I know you often go to UPSC and you are a friend to mine. Okay. Thank you very much. So I live at Chebi, where we have 3 courts, District Court, Circuit, and High Court. Can I choose to have my case settled outside Chebi or for geographical reasons? Oh, it depends. If it's a civil case, you have to be guided by the venue, the rules on venue in... So, Philip Ankoma, if you're hearing, if it's a civil case, you have to be guided by the rules in CI 47 and CI 59. And then the monetary limits as well. So, it depends on what case you have. If the rules on venue under CI 47 as amended or CI 59 as amended, as the case may be, allow you to do it in Chebi, fine. Yeah, but with the 3 courts there, I think you will have to do it. Unless the defendant, so for example, under Order 3 of CI 47 as amended, you have to sue where the defendant resides in any other suit. They are outlined there. If it is about a landed, an immovable property, it is where the immovable property is located. If it's about any other claim, then where the defendant resides. So if someone has come to take your money, Philip, and you want to sue the person, you have to know where the person resides or carries on business. So if that person is in Koforidua, you have to go to Koforidua to go and sue. If they carry on business in Koforidua, you have to go to Koforidua. But if they carry on business in Chebi, but they live in Koforidua, you could either sue in Koforidua or Chebi, depending on which one you choose. So deciding on which court to choose, there are lots of things that go in jurisdiction-wise. Okay, you have to look at the monetary limits, you have to look at geographical, you have to look at so many aspects. Okay, you have to look at forum, venue under CI 47 as amended or CI 59 as amended. I keep mentioning CI 59. CI 59 as amended is the rules book, civil procedure rules book for district courts. CI 47 as amended is the civil procedure rules book for circuit and high courts. CI 16 is the civil procedure rules for Supreme Court, and CI 19 is for Court of Appeal. So all the courts have their rules books and they are guided by them. Those are the rules of procedure. All right. 2020. What happened in 2020? My Lord, CAF University needs you urgent. Please, you have truly opened my mind. CAF University needs me urgent. Well, I'm sure CAF University have watched a lot of my webinars, so well, we'll see how it goes. My lady, I'm praying you will soon be elevated to the High Court. You are more than qualified and you meet all the criteria. Well, from your lips to God's ears. Thomas wants you to come and lecture at Central University. I see. I'm just one human being. If you end up splitting me up all over the place, I'll be so overwhelmed. In any case, I'm always available for webinars. You know, webinars are good because we get everybody from all universities. So we shouldn't treat most of our legal platforms like Super Law and the rest to organize more webinars like this and get myself and my colleagues to, as industry personnel, to help. District Court 500,000. We are there. Land dispute has been placed there. We shared LI 2429 on the WhatsApp chat. Thank you very much. Very, very clear. Crucially, the parties may agree because statute good, Nanayao. But why the civil proceedings on charges on Order 47 has not been amended? I don't know. I don't know what they are doing. Very nice. Respectfully, my lady, what would you consider an ideal number of justices from this? Hey, Shehu Shagari, what would I consider as an ideal number of justices for the Supreme Court? What is ideal? What is ideal is not statical. What is ideal will be evolving with time and the needs of the society. If we are inundated with cases for the Supreme Court, then it will mean that the ideal situation would be that it is increased. So, as of now, I have no opinion on that. Let the policymakers and those who make decisions decide on that. I will not carry that burden for you. Sorry, I'm not going to answer that question. The ideal number, I don't know what ideal is. Should a civil matter take place in one region, can a suit be brought in another district court in another region? You mean the civil course of action accrued in one region? That's why I was saying that before you sue, you have to look at the rules on venue under Order 3 of CI 47. If it's a district court, go and look at the rules on venue. If it has to do with immovable property, you have to know where the immovable property is situated and sue in that district or region. If it has to do with a liquidated claim, an amount of money, etc., you have to sue where the defendant resides or carries on business. So there's a rule. There are rules on where to sue. So you have to read Order 3 of CI 47 and then CI 59 to know which is the appropriate forum to sue in. Who is a judicial officer and what is the role he plays? Judicial officers is the lower bench judges and then the registrars. We are all judicial officers, okay? The judge of the circuit court, the magistrates, and then the registrar. We are judicial officers. Do you know that the magistrates, we have career magistrates and we have professional magistrates? So we have people who are lawyers who are magistrates. Like me, I started from the magistracy. So I came in as a lawyer. And then I was appointed a magistrate in 2015. But we have career magistrates who are from other professions. They are not lawyers. And they were called upon to step in as a step-in gap. You know, they saved the situation. Career magistrates saved the situation. We were lacking lawyers to sit in the magistrate courts. Meanwhile, our communities have spread and expanded. And we needed magistrates in all communities. And we didn't have lawyers coming because, first of all, because the conditions of service were terrible. So lawyers were not interested. Why should they leave their lucrative businesses and come and join the magistracy? So we had to fall on these professionals from other fields, teachers, nurses, and other civil servants. And then the judiciary trained them over a period and made them magistrates over these remote, underserved communities. That is why I wrote the paper recently on May Day, congratulating lower benches for holding the fort, because these are places that lawyers don't want to go to. Lawyers don't want to take up the lower bench work because the remuneration is not good enough. Our colleagues, sometimes if I look at my colleagues who I finished law school with, they are in private practice. If you look at how much wealth they have accrued over time, the fulfillment, if the job is not your passion, you would give up. So the career magistrates came in to fill the gap, and they are still in the system. So far, we have not been employing career magistrates anymore. The judiciary doesn't employ career magistrates any longer, but they are in the system because they've not retired. Some of them have gone to law school and have become lawyers, so they've transitioned into becoming professional magistrates, but they are still there, and we applaud them for their work and their sacrifice. When lawyers were unavailable to go to the remote, underserved areas, these are the people who saved the day. We should, next time you appear before a career magistrate, give them the respect they deserve. They are doing the work lawyers are supposed to be doing, and yet we do not give them the respect and the dignity they deserve. They deserve better. Yeah. Why do we call the justices at the Superior Court justice and then Supreme Court as judge and district court? No, I think I gave you the nomenclature, so I will not go over that again. Should a civil matter take place? Okay, we've had that conversation. I think they use the title "My Lord" as a means of persuasion. Really? You call all of us "My Lord" so that we feel good? No. Yeah, it doesn't carry anything. It's the law you are about to espouse that would determine whether you win your case or not. There's no feel good about it. Does the registrar have to be a lawyer? No. Is it strict for the interpreter to be? No, I've answered that question. Should a civil matter take place in one? Okay, I've answered that. Please, the number of panel for each court. Okay, so the Supreme Court, five-member panel for ordinary cases, review panel 7, constitutional cases 9. But a single judge can sit as a court for purposes of motion. Court of Appeal 3, but a single judge can sit for purposes of motion. High Court, single judge with jury sometimes for trials on indictments. Circuit Court, 1 judge. Magistrates, 1 judge for civil and criminal cases, but a panel of 3 for family tribunals and juvenile courts. I hope you got that. Was it too fast? Sometimes I speak really fast. I'm sorry if I speak fast. Let me say it again. Supreme Court, 5-member panel for ordinary cases, review panel 7, constitutional matters 9, but a single judge of the Supreme Court can sit on motions. Court of Appeal, 3-member panel, but a single judge can sit for purposes of motion. High Court, single judge, but for high treason, their panel, and then jury trials too, they sit with the jury. Then Circuit Court, 1 judge. Magistrates, 1 judge for civil and criminal, but panel of 3 for family tribunal and juvie court. If an accused person at the court needs interpreter, who pays for the cost? No. Interpreters, and nobody pays. Even in civil cases, you are not supposed to pay anybody for interpretation. The registry is supposed to take care of that. If the interpreter is coming from Ghana Institute of Languages or somewhere else, the registry pays for that. It's not the cost of any litigants or any party. How much more in criminal cases where the accused is innocent until proven guilty? Why should the accused be spending money in courts? No, nobody pays for interpreter in courts, civil or criminal. Yeah. I cannot see. If an accused person if an accused person at the court needs, okay, that's the one. Glad case, nullum crimen sine lege. Yes. Yeah. Yeah. Hold on. All right. So, does high courts have supervisory jurisdiction over national? No. Original House of Chiefs. No, 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 no. They do their work. The traditional council, regional House of Chiefs, national House of Chiefs. So the national House of Chiefs will have some supervision over the regional House of Chiefs, and the regional House of Chiefs will have some supervision over the traditional council. They are in another parallel channel running alongside the normal courts, okay? But just that when they finish their work at the National House of Chiefs level, it goes to the Supreme Court. So no other court has any supervision over them. Does any church marriage constitute a marriage by ordinance? No. No, no, no. A lot of people are married in churches. They don't know they are not married under ordinance. Your church has to be gazetted. You need to find out if your church is gazetted before the marriage conducted in that church will be considered a marriage under the ordinance. And so a lot of the churches that are not gazetted, or the priests who are not gazetted to be marriage officers, you have to be a marriage officer. The venue has to be a marriage office. So the gazetted churches are marriage offices. One of the requirements is that the marriage should have taken place in a marriage office, and the person officiating has to be a marriage officer. So magistrates are marriage officers, and then the registrar of marriages to their marriage officers. The priests and pastors, etc., who have been gazetted to be marriage officers are marriage officers. The premises, event premises like Labadi Beach, Aviation Social Center, Unique Flora. There are many places that have also gazetted themselves. They've been gazetted as marriage offices. So when you conduct your ordinance marriage, there is valid. And then the officiating person has to be a gazetted person or a person lawfully allowed to conduct marriages. So if your church is not gazetted as a marriage office, please, it is not an ordinance marriage you went to perform. It was just a blessing of your God and your church that you went to perform. That's why most people go to the district assemblies or the courts to do the signing, and then they come and do the church blessing as a religious activity, okay? Yeah, there are strict rules when it comes to validity of marriages under the ordinance. So you have to ensure that the marriage office is a marriage office, the event place is a marriage office, and the officiating person is a gazetted marriage officer. Otherwise, you are participating in a brutum fulmen, a complete exercise in futility. You won't be married under the ordinance. Your Honor, Akpesia Mauna Yirao, hope you rise to the Supreme Court by merit soon. From your lips to God, yes, and you're welcome. Thank you. Respectfully, I would humbly request for your contact with all humility. Hey, you don't give contacts by heart, by heart. Please speak with the convener of this meeting to ascertain what it is that usually you can privately message me on LinkedIn. Okay, if you follow me on LinkedIn and you send a message, I would respond. Then I'll take it from there. If it is of utmost importance that we communicate directly, maybe there's a difficulty that you need help with, then we'll see it. I'll exercise my discretion. But LinkedIn, you can send me a message on LinkedIn. I am Judge Sedinam Kwadam on LinkedIn. Okay, you just search for me. You see my image there, and then you can send me a message. Daniel Azaglu. I pray you rise to the Supreme Court from your lips to God's ears. Amen. Could you explain a prima facie? What is a prima facie? Prima facie is on the face of it. Instantly, on the face of it. Prima facie, on the face of it. That's all it means. Or you mean it in another sense. I mean, you have to put it in context. But I am explaining the meaning of the phrase prima facie. It's on the face of it. Okay, on the face of whatever it is. So if they are finding a prima facie case against an accused person, they are saying that on the face of the evidence produced by the prosecution, it shows that the accused has a case to answer. That's prima facie for that particular context. In any other context, it means that on the face of the matter, a conclusion has been drawn. So it literally, it means on the face of the matter, okay? Should a civil matter take place in one region? Can a suit be brought? Oh, that same question. Currently working. No, it depends. As for forum, there are many factors that you have to take into consideration. So you have to give more facts than that for us to decide which is the right forum. Ghana Joel, please, my lord, in what ways does the Supreme Court shape national identity and cultural norms through its interpretation of the Constitution? You answered your question within the question. Yes, the Supreme Court's decisions will naturally shape the national identity and cultural norms through the interpretation of the Constitution, because it is in the interpretation of the Constitution that they give form and structure to the law. So they are given facts and people are confused about it and they come to the Supreme Court for interpretation. The decision of the Supreme Court will give flesh to it. And so naturally it will be shaping the norms and national identity of the people. If you come with a suit that this practice is repugnant to natural justice and is unconstitutional, by the time the Supreme Court finishes speaking on it, we would have formed a norm in that context that, henceforth, this particular practice is not part of our identity as Ghanaians anymore, or as Akans or as Ewes anymore. So yes, that's why I said you answered your question in the extent is real. Is real. It's a real thing. It's not just apparent. The Supreme Court's decisions are always shaping our cultural norms and identity constantly. If you take the citizenship, for example, the Supreme Court's decision has shaped it, where your birth certificate is no longer the valid, decider of your identity or your citizenship as a Ghanaian. It is your Ghana card. So that is a decision that has affected the national identity of the people. So it is not apparent. It's not a figment of our imagination when we say that the Supreme Court wields so much power that every decision they make is weaving the fabric of our identity as a people, whether it be our rights, human rights, or procedure, criminal procedure, or other aspects of our identity as a nation or as a people. The very decisions that are being made affect us to the tiniest detail. And that is why the advocacy has been that there should be some consistency as well as, due regard to the needs of the people. Yeah. Please, who is a judicial officer? What role? Okay, so the judicial officers are the lower bench judges and the registrars, and we play a pivotal role in the administration of justice. All lower bench judges adjudicate cases. I've told you about the jurisdiction, etc. Right? So yeah, they play a pivotal role in the administration of justice at the community level. We bring justice to the people in the remotest places, underserved places in the country. We are the first point of call when it comes to access to justice. The district court magistrates, the circuit court judges, the registrars of these courts, the judicial officers do a great job that is under-recognized, if recognized at all. And the remuneration and conditions of service are not the best as compared with other Commonwealth countries as well. I cannot hammer this enough, and I'm not embarrassed or shy to say it. Other people may hold other views, but when it comes to the Commonwealth, the lower bench judges are the least paid, and judicial officers deserve better than that. I will always speak for us in this regard. If the policymakers are listening, they should do better. They should do better. It's basic human rights. How can a judge who jails armed robbers not have a bodyguard? But we've got parliamentarians who don't jail armed robbers walking around with bodyguards with arms. A judge, for example, sitting at the circuit court in Adenta, I jailed so many robbers. And then I'm walking around without a bodyguard with no arms. The CWs in our courts don't have arms. Nothing. So where is the justification of that? Judges who jail robbers don't have bodyguards with arms, but other workers who don't jail robbers are people walking around. We are not saying they shouldn't, but at least the people who are also doing very risky work should be protected. We also belong to families. We also have families, and we matter to them. So after jailing robbers, when I'm going home, I see the motorbikes parked. Their friends come to court. You don't know their friends come to court. Their friends come to court. They see you sentence them to 40 years imprisonment, 35 years imprisonment, and you are walking out going to your car, your small rusty car, and you are driving and they are chasing you. And you don't have a bodyguard with arms. And nobody finds a problem with this. So I have taken the step. If it is an offense to tell the people who matter that we are risking the lives of lower bench judges, then may I be an offender always. Thank you very much. Those are the judicial officers. Thank you very much. Excellent presentation, great passion. For someone with no legal education, you made it easy for me to follow. Wow, that's impressive. Thank you. Cramming as it was in the beginning ever shall be. No, it will change. It will change. It has to change. It must change. We are the people at the helm of affairs now. We are the future. So if we decide it has to change because we've evolved, it will be. We must will for it to change, justify our request with cogent evidence abroad and elsewhere, and explain ourselves. If it makes sense, why wouldn't it change? Empty, why wouldn't it change? It will. We must be willing to fight the good fight. Your Honor, as by law established, kindly tell Nanayao to email us your papers. This will make it easier. Okay, so Nanayao, if you can email or post on your WhatsApp group or something, all the articles I mentioned, that would be fine. Email it to them. Thank you very much. What's the geographical jurisdiction? We're almost done, okay? What's the geographical jurisdiction of the circuit courts? It's actually regional, but because circuit courts are now in many districts and MMDCs, they restrict themselves to. So Adenta will deal with cases around Malijo, East Legon Hills, Adenta, Medina, circuits, all those areas. And then Accra Circuit will deal with different. Tema Circuit will also deal with those around Temakung, etc. So it's usually regional, but now that we've decentralized it, they'll take care of the MMDCs as well. We often see people mercilessly beating up others alleged to be homosexuals. Although homosexuality is against our country's moral standards, do we have the right to be beating them up, especially when the law has not been passed on that yet? There is no law that allows anybody to beat anybody up for any crime, whether the crime is prescribed by law or it is perceived by morality. If you feel that somebody is offending your morality and it is not a crime, you don't have a right to beat the person. Even if it is a crime, you don't have the right to beat the person. That is assault. That is battery. That is a crime in itself. We cannot purport to be a law-abiding country when we say that if we think somebody has stolen something, if we think somebody is a homosexual, if you think somebody is an adulterer, beat the person up. That is how innocent people get killed. Do you recall how Major Mahama was killed? That is how people get lynched. So it doesn't matter whether it's homosexuality or stealing or robbery. That is why law enforcement is available. Now, I believe that it is because there's no, there's a natural canal knowledge, but you'd have to see the person having a natural canal knowledge. You have to be observing the acts taking place before you can call the police or effect citizens' arrest them and bind them and take them to the police station, right? you'll have to see the natural canal knowledge taking place. And that's a very rare, even for natural canal knowledge, how many times do you get to see people having natural canal knowledge? Not to talk of something that has been prescribed, and natural canal knowledge. You would hardly see people having a natural canal knowledge to the point of effecting a citizen's arrest or calling the police to come and arrest them. What are you doing in their bedroom or in their corner where they are having their natural canal knowledge? But be that as it may, there is no justification morally or legally for anybody to take the law into their own hands and beat people up for being homosexuals or being thieves or being armed robbers. No, no, no. You either effect citizens' arrest, you all gather and you capture the people and bind them together, send them to the police station or call police patrol to come for them, or you call the police to come and effect the arrest if you can't do citizens' arrest. But as for beating, mob action, what do you call it? Lynch? No, 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 no. It's a no-no for every type of allegation of an offense having been committed, or homosexuality, which is not a crime. Homosexuality is more than just having a natural canal knowledge. That is why I'm separating them. Having a natural canal knowledge is a crime. It is in our law. If you have a natural canal, if you are seen having a natural canal knowledge, it's a crime. And the Supreme Court has stated that natural canal knowledge is penal vaginal intercourse. So anything outside of that, including fellatio, cunnilingus, anal sex, all the other ones that don't form part of penal vaginal intercourse, all those ones are natural canal knowledge. It is not the fact of the gender that matters. It is penis and vagina intercoursing. That is the only one that's natural canal knowledge per the description given by the Supreme Court, right? But every other one is unnatural. So if you chance upon somebody giving fellatio, what in common language they call blowjobs, if you chance on somebody giving cunnilingus, leg shots, if you chance on somebody having anal sex, and you happen to be there, that's a crime happening right in front of you. You can do citizen's arrest if you're able to, or you can call the police to come in. But as for beating, I'm sorry, I have to say this with all the seriousness I can muster at this point. Do not beat anybody up for committing any crime, according to you, because you are not the law. You are not the law. You don't determine what is a crime and if that crime has been committed. You must bind the person up, capture the person, hand the person over to the police, or call the police to come and effect the arrest. And then they will look at the evidence and see if they can prefer charges and take it to court. And even then, after taking it to court, it is only the court that can convict the person. So at the point of beating the person up, you have jumped many steps. And you have taken into your own hands powers you do not have. That is my answer on this matter. I really like your style of teaching. Thank you. Please, my Lord, in what ways does the Supreme Court shape national identity? Okay, I've answered that. I once experienced you at Adenta Court, and I've always looked forward to listening to you again. Kwamina Taylor, thank you very much. I appreciate the feedback. Promise you will visit us at CAF University. Hey, I should promise. Okay, you have to invite me for the visit. Tell me what you want me to come and do as a guest lecturer. Get your dean or vice dean or lecturer to do the invitation to me, and then tell me what exactly you need me for. If it falls within the code of ethics, our boundaries, like what I'm doing today, then I'll do it. Why not? I'm available for helping with legal education. After all, if the bar becomes better, it affects my work as a judge. A great bar makes a great bench. So if we help in legal education training, it's the better for all of us at the bench, okay? What type of trials require jury? The law says that if the trial is described as, if the offense is described as a first-degree felony or even any other felony that the law says must be tried. So the mode of trial is prescribed under Act 30, the Procedure Rules, Criminal Procedure Act, Act 30. If the procedure says that this offense must be tried on indictment, then we'll use a jury. If it says that it must be tried summarily, then it's only a judge, okay? So it is the type of offense. So for example, rape is a trial on indictment offense. So it is judge and jury. Murder is the same. Manslaughter is the same. So for these ones, it will be the trial judge and the jury. So trial on indictment is judge and jury, but it is the law that must prescribe the mode of trial, either summary trial or trial on indictment. If it says trial on indictment, it is judge and jury. Do the circuit courts adjudicate on criminal assize? No, we don't do that. We don't do trial on indictment. We cannot give sentences beyond life imprisonment. It's up to life imprisonment for us. We don't do jury trials. It's just one judge, circuit court, one judge. And the highest we go is life imprisonment. We don't do death penalties. Even death penalties for the whole Ghana, it's been done away with. So, yeah. We don't do trial on indictments. So no criminal assizes or jury trial for circuit courts, okay? We do summary trials, only summary trials. And our sentencing is from fines. The fines, there's no limit for us, circuit courts, no limit for the fines. District courts, there's a limit, which is 500 penalty units. That's the maximum. Circuit court, no limit for the fines. But circuit court, you can sentence up to life imprisonment. But you have to look at Act 30 to know the limit of the sentence for that offense, or even Act 29. So you see that for rape we don't do a circuit court. For defilement, it's from 7 years to 25 years. So we are always guided. We are always guided. There's a limit, okay? But we don't do death sentence. We don't do trial on indictment at the circuit court. The district court does a procedure called committal procedure. I didn't mention that. I'm sorry. Committal procedure is a preliminary hearing where the summary of evidence is presented by the Attorney General against an accused person who has been accused of committing murder or rape, and a trial on indictment. If the trial has to be on indictment, we'll start with a committal proceeding before a district court. So the district court has that special jurisdiction as well. It doesn't mean that it's only the district court that can do committal proceedings. Sometimes a case can be going on in a circuit court. Then all of a sudden we realize, this case should have been done as a trial on indictment. So we have to do a committal. That circuit court or high court can sit as the committal court, like a district court, and do a committal proceeding. But after the committal, that court cannot sit as the trial court. You have to commit to another court for them to do the committal. Look at section 179 of Act 30, section 179 of Act 30, it's there. But committal proceedings generally is that the Attorney General will produce a summary of evidence. It's called a bill of indictment. So when there's a murder case or a rape case, the Attorney General will produce a document called a bill of indictment. It contains a summary of evidence they propose to prosecute the case with. Now, the magistrate will sit alone in the court looking at this bill of indictment and assess whether there is sufficient evidence to support a finding that the charges will be supported and can be proved at the trial. If the magistrate makes that finding, the magistrate will commit the accused person to trial before a high court. That's what is called committal proceedings. So every time you hear of a murder case or a rape case being handled at the district courts, that is what is happening. We are ending now. Please, what is your LinkedIn? Okay, they've posted it. The right to an interpreter is provided. Good. For those of us who would like to follow my lady on LinkedIn. All right, thank you. Why then police beat up suspects in the name of application of minimal force? I think we'll have to ask the IGP about that. They should answer. They are not supposed to, okay? Article 2.1, what are the implications of 2.1 on the power of any citizen to challenge unconstitutional acts, and how does this provision empower the Supreme Court as the guardian of the Constitution? Oh, if you are a citizen and you think that there's an unconstitutional act going on, you have to institute the suit before the Supreme Court. You have to issue the writ before the Supreme Court. Yeah, you have to institute a suit. Yes, hold on. You see, you could invoke the original jurisdiction by a writ of interpretation or enforcement of a provision of the Constitution. So you look at Article 130 of the Constitution, that's how you go. You invoke the original jurisdiction of the Supreme Court by a writ for interpretation or enforcement of a provision of the Constitution. That's how you go about it. Okay. And for other ones too, there are ways and means. So you look at the Constitution, depending on the claim you have, then you go about it. Okay. Okay. So are there any hands raised? I'm done with the comment section. Are there any hands raised? Is there anybody who wants to make a comment or ask any question? You're welcome, Joel. It doesn't look like we have any questions, do we? Any hands up? Convener Nanayao.
My lady.
Yes.
Yes, I don't see any hands up. If you have a question, may kindly raise your hand and we'll invite you to put your question down. Somebody is asking when our next session is. I think that will be largely dependent on my lady's calendar.
Well,
all right, I think there are no more questions. My lady, we are very grateful. You've taken your time out of a very, very demanding schedule to deliver this insightful and very thought-provoking lecture to us. We are very grateful. In fact, when you started, you likened the Ghana legal system to a farm. I found that to be a very interesting metaphor. It means that we have to tend it with care so that we can obtain the fruits thereof. I also associate myself with the prophetic messages that have been shared here. Indeed, the High Court, Supreme Court, and beyond, from our lips to God's ears. I think somebody's hand is up now. This is Justice. Justice, please go ahead.
Yeah, thank you very much. Actually, my name is Noah, but I'm using a friend's ID.
Okay.
Where I'm those born before computers, so some of this we don't know how to change the names. But I must say thank you, my lady, and then we appreciate your presentation, and then I also observe your passion for advocacy and the way you go about things. There's this thing that has also been in my thinking. If you look at the lower courts, basically it is chief inspectors or inspectors that represent the AG at the lower court. And if you look at it, most of times they go for 6 months training at the law schools in criminal prosecution, evidence, and all things. But then I am of the view, like you're saying, you keep on saying, if the policymakers will think of this, we have a lot of LLB holders who have done law for 4 years, some 3 years, and they've done a lot of, they studied a lot of laws, of which when we give them this application, because it looks like the law of natural justice is most of the times are not applicable at the lower courts, because you have a police doing the arrest, taking a complainant, even the CID will come and testify, and you have the same police also prosecuting. So it looks like most of the times when they come to the district court, I have been at district court, I have been with them, and sometimes they will even lure some of the suspects to go. When you go, plead, say, oh, I'm guilty with explanation. If you don't do that, they may take this. So I was also of the view that if we can have another leg of training, like lower prosecutors, unlike as we had the career magistrates with LLB holders and taking them into prosecution and other things, they will be specialized in prosecution so that the police will be free to go and handle the motor case, to go and have, because you have a policeman arresting a car, bringing the same car, and then the driver will, it's just like you against me. And then if you sit in as a judge, you will realize that most of the evidence being adduced against the suspect, for want of maybe they don't know their rights, they don't know what the laws even says and other things. You see that they bring some of the cases that they even bring to. You sit in court and then the magistrate will advise that, oh, if you look at this and that, this need not to get here. And for me, I see that we are putting a lot of innocent people behind bars. And if we can separate the police work from prosecution, I think it will go. So I also advocate for your writings to look at that angle too. Thank you.
Thank you so much, Justice. I appreciate that feedback. And also, I agree with you that the legal training being done in the law school is so one way. Either you become a lawyer after, and then that is it. But we could train people to work even with the LLB, and the AG's department, which says that they are understaffed, can utilize all these LLB holders in training them in prosecution so that the police can be less burdened, because we had to incorporate police prosecutors because the AG's department did not have enough lawyers. But now we have so many people with LLB. You are so right. We have so many people with LLB. And of course, because of the entrance exam into the law school, it's taken some time for some people to get in. And still, they've got this wealth of knowledge from their LLB degrees, and they are just sitting at home doing nothing, just struggling to get into law school. I think this is a fantastic idea. Don't leave it to me alone, because I've got my table full. I think you yourself should write the suggestion as a paper and a policy suggestion, give to the AG's department. They can see. Even workers at the assembly, district assembly, sanitation department have been trained as prosecutors. So we've got sanitation prosecutors, we've got ECG prosecutors, we've got SNIT prosecutors. All these people were just trained. So why is training of LLB holders such a far-fetched idea? It is not. In fact, thank you for bringing it up. And I do hope that you take it up as a personal project of yours to send a policy to Justice Srem side, the Deputy AG, because he's into academia as well. He was a lecturer and all that, so he will fully appreciate. And even the Attorney General, I'm sure that if we suggest this, if you suggest this, it will come out as the next, the next bullet to kill some of these problems that we are facing. What you've narrated is the reality in the lower bench with police prosecutors. That is the reality, But I support you. I support you because this idea is great. And if you need any help with putting it together, we could put it together and put it to them, because you have to do a research probably in the lower benches, get your figures right, and then advocate for it properly. But it's a project you should take up. I'm available for support if you need me. Thank you very much. Nana,
yeah, we are grateful. We are grateful. So I think we should round up right now. We are most grateful, my lady.
Yes.
Indeed, if you have any write-ups, you can send them. We'll publish them free of charge. Also, if you have indeed registered, then you will obtain the recordings. Either you register or you join the platform, you will get the recordings afterwards. So, my lady, we don't waste too much of your time. Thank you so much. Thank you so much. And thank you all for attending.
Yeah. Thank you, everybody. Have a beautiful weekend and a blessed week next week. It's been an honor and a privilege as always. Those of you who are inviting me to your universities, please do the right thing. Thank you. God bless you all. Bye-bye.
Bye-bye.